death reference and the connected appeal are taken up for consideration analogously as they emanate out of the same order of judgment of conviction and the order of sentence. First up, next paragraph. Appeal was filed by a learned advocate. First up, next paragraph. We requested the learned advocate for the state to inform such advocate for the appellant yesterday, which the learned advocate for the state did. First up, she reported yesterday to us that, the learned advocate for the appellant told her that that he gave no objection to the appellant. First up, next paragraph. None appears for the appellant today. First up, next paragraph. In such circumstances, Mr. Mondal, you will have to do the honors, death reference and the connected appeal. How many prosecution witnesses, ma'am?
34.
34. The reason may be given so that paper. We appoint Mr. Kollol Mondal, learned senior advocate, as the advocate for the appellant and the. Take a choice. Tell me your name. We appoint Mr. Kollol Mondal, senior advocate, and Mr. Onomito Banerjee, advocate, as the learned advocates for the appellant and the convicted in the appellant in the appeal and the convict in the death reference. First up, next paragraph. Department will make over a paper book to Mr. Onomito Banerjee, advocate, forthwith. First up, next paragraph. Ask your junior to collect it from the department. State SLSA, or will direct the High Court Legal Services Authority? SLSA. Secretary, State Legal Services Authority is requested to regularize the appointment of the two learned advocates as directed herein. First up, next paragraph. State will submit a report in view of the convict is suffering a penalty of death, state will submit a report in terms of to 2023 volume 2 Supreme Court cases Manoj and in particular paragraph 250 thereof on the next date. Full stop, next paragraph. We keep it just before the vacation so as to ensure that everything.
Monthly list of June. Yesterday also those matters were fixed on.
No, those were the reports came.
Also, my lord. Those were placed yesterday.
At least let him get the paper book. So let us see that his appointment is regularized. You wanna? First term next part. List the that reference along with the appeal on May 19, 2025, when the report has called for, be submitted. I mean to এই ডেথ রেফারেন্সে পেপার বুক গুলো নিচে সবকটাকে ডিজিটাইজ করে তুলতে বলুন, সবকটা ডেথ রেফারেন্সকে ডিজিটাইজ করে দিতে বলুন।
Response number 1. Your Lordship's pleasure.
I'm appealing for the response. I am appealing for the response number 2.
Yes, sir.
I'm appealing for the response.
Your Lordship's pleasure was to ask me to check up whether the judgment cited by Mr. Bhattacharya was taken up in appeal. I have, not I, my junior has checked up, and I find that the ERJ case that was cited, that was taken up to the Supreme Court. But the Supreme Court set aside the judgment in view of the fact the order has already been complied with. Therefore, if that is set aside, I may hand up the judgment of the Supreme Court.
So the point of law is still open.
Yes, still open. No, point of law, the judgment is.
From your point of view, point of law is what you say.
Yes.
But through this judgment, the point of law is still open.
But
The Supreme Court decided that nothing remains.
I say,
My lord, when a judgment has been set aside, my lord, the entire
Sir, let one at a time. Yes, please.
the point of law, I submit, is closed, not open, because so earlier Supreme Court judgments, they hold the field, and here the judgment which Mr. Bhattacharya was relying upon has been set aside. It says
On
language
compliance. On compliance.
on compliance, because if your lordship sees,
On compliance.
on compliance.
It doesn't say that the jurisdiction is decided.
No, no.
One more question to all of you. What about the special bench of our High Court, which says that even if there is a modification of the this thing by the appeal court, then also the first court gets to
Modification.
That is in view of Rule 15 of the Contempt of Court rules of this High Court.
which will not be attracted so far as a merger in respect of a judgment with the Supreme Court's judgment.
Because Rule 15 of the Contempt of Court rules of the Calcutta High Court specifically saying,
Because special bench is also binding on us.
yes, special bench is also binding on us because special bench has decided it on the view of Rule 15. Therefore, this question which we are now canvassing before your lordship has nothing to do with
That question was also before the special bench.
Modification of the division bench.
My lord.
No.
If I may.
Clause 2 says modification.
I am a state father. Supreme Court judgments are placed even of 2025, which says even in case of affirmation, this is much. 3 aspects. If it is
Affirmed, modified,
or
Reverse.
reversed,
merger.
in all the cases.
But untouched, if the special petition is not taken on board, not admitted, then another one.
Yes. Then, Lord, of course.
So the test will be whether or not a review is available to us. If a review is available to us, then we can enforce it.
Yes.
If review is not available to us, then it ceases to exist, and it ceases to exist for all practical
All
purposes.
practice.
That
all
is your
practice.
submission.
Yes. And Lord, one more thing before I. No.
And there cannot be reply to reply. No,
That's right.
don't provoke him, please.
Show that the judgment supports me.
All judgments support him. What
Very
can I do? No.
All judgment suppose the respective parties. Very good. No.
But only one more thing, that your lordship's pleasure was to hear Mr. Bhattacharya on Article 215 of the Constitution
And to 129.
129. Now, kindly have a look at those two provisions. I don't know how this is of any of any relevance in our case, because these really give jurisdictions. If I may just take your lordship's time for
আরেকটা কনস্টিটিউশনের বই দিন পেয়েছে ঠিক আছে আমি পেয়েছি ঠিক আছে আছে আমার কাছে
kindly see 215 high courts to be courts of record. Every high court shall be a court of record
same words used in 129
and shall have all the powers of such a court.
What is your what do you want to submit?
I see, including the power. It quotes the high court with a power. General law. But when the Supreme, I want to say that under Article 141 of the Supreme Court says it's also law. Therefore, the law laid down by the Supreme Court is also holding the field.
Yes.
Therefore, when the Constitution simply says that High Court will have power as a court of record, Supreme Court will have the power as a court of record, it does not say under what circumstances and who will have jurisdiction. Jurisdiction aspect is not dealt with either by 129 or by 215. I never say that the High Court does not have any power to punish for contempt because it's a court of record. But I say when it merges with the order of the Supreme Court, where
As I see it, if it was an act of contempt on the face of the court, like here
oh,
is
yes,
a
yes.
contempt.
If I just say something,
So then we could have intervened and should have intervened, notwithstanding our judgment getting merged with the Supreme Court.
certainly,
Now, whether on the principle of merger, whether we get denuded of our jurisdiction is something we will consider.
grateful to you.
Now, my lord, can I make submissions, my lord?
Please, yes.
Yes. Now, my lord, kindly see first judgment, that is the Rampal and another versus B.S. Palla, which Mr. Sengupta has already submitted that the judgment has been set aside. Now,
Right.
the question has come from, fallen from your lordships. The laws are there. The number one is, when a judgment is set aside, it's entirely set aside.
Yes.
Number two, if the points were required to be left open by the Supreme Court while setting aside of the judgment would have written the points were left open.
Right.
Lord, normal cases is this: when a SLP is dismissed or Lord, any even at the admission stage it is dismissed, the Supreme Court keeps the point open to decide later on. But here, Lord, there is no Lord, the order which has been placed before the lordships of the Supreme Court, no points were left open.
Very well.
Therefore, there is number three is this. My lord, when a judgment is set aside, my lord, with great respect, my lord, there cannot be any dichotomy of the judgment, the dichotomy of the order, that whether this part has been remained or this part has been remained. It is entirely, it has been set aside. Now, my lord, this is the I am submitting, my lord. Next, my lord, the judgment which was cited by this another case, another one, that is, my lord, that the Mariamma Thomas case. Mariamma Thomas, that is 15 SCP online, 41310, 17 December 2016. But, my lord, although no appeal has been preferred against this order, but by a subsequent judgment of that Kerala High Court, in the case, my lord, kindly hand over the judgment, please. Who is there? Kindly hand over the judgment. Amit Matthew.
Yes, yes. Mariam.
Amit Matthew, please. Amit Matthew, my lord. Kindly come to paragraph 9 of that judgment.
আরেকটা ধারের কপি ও এটা দিয়েছো হ্যাঁ সরি
One more copy, please.
yes yes right. One after the other.
Applies to contempt proceeding, we are constant to hold that the principles of law has not been correctly laid down in Abhin's blood. The point is that your lordships in blood, the consideration is this now, whether because of this division bench judgment, although in the first no appeal has been preferred, but it has been overruled already. Although it has not been, my lord, your lordships have considered this question in the Samsung's case. when it is overruled and when it is not overruled. Samsung's case, your lordships have considered, my lord, therefore, I do not want to take your lordship. Now, my lord, one of the consideration would be, my lord, which is the paramount consideration, my lord, which is binding. My lord, oh, sorry. Third point is, my lord, I am sorry, my lord, the special bench judgment of this court. My lord, on the first day I submitted, kindly see there is a distinction between a procedure availability or the procedure availability for getting the justices. One is statutory appeal, another is the constitutional provision. Now, Lord, which will prevail? Certainly, Lord, 136, kindly see this, 136 of the Constitution of India, may I just read? It speaks about that special leave to act by the Supreme Court, notwithstanding anything in this category. The discretion grants special leave to appeal from any judgment, decree, or order in any cause or matter passed or made by any court of limitation. Nothing in this shall apply to any judgment, determination, or terminal. There were 136 provisions, my wife, which I want to submit before Lordship, like a 226, like a 32 is a constitutional provision. 136 is also a constitutional provision. It is not a statutory appeal, cannot be upgraded like a the constitutional provision. Therefore, justice, the judgment of the special bench doesn't stand in the way here. Does not stand in the way. Lastly, what which I will submit, the number of judgments have been placed by us, and they have cited two judgments. One is another one is Kerala. I have cited another judgment of the division bench of the Kerala, which shows that impliedly overruled. Now, therefore, today's question is before your kindly. For your lordship's consideration, I will request your lordships to consider whether the Supreme Court judgment which we have cited before your lordships, that binds your lordships under Article 141 of the Constitution, or your lordships will take or have any persuasive value of any other judgment, including the judgment. My lord, kindly, just since your lordships have made an expression, the special bench judgment is binding. Which judgment is binding? Comparatively, whether Supreme Court judgment is binding or the special judgment is binding. Lord, there my submission would be, Lord, the Supreme Court judgment is binding on your lordships on Article 141. Lord, the judgment of the higher court is binding only because of the judge's interpretation, judge-making law. Nowhere it has been stated, no law is there that is binding.
Mr. Banerjee, we will be now facing a technical glitch.
What technical glitch?
Your audio might get off.
Oh, sorry, Mary.
Normally it is done. That is when I appear.
No, it's off means your lordships are not here. Am I not? I am not audible.
Yes, up to now, yes.
No, need not be worried. I have enough stock.
Yes, very good. Then Mr. Basu, yes, sir.
I will take only 1 minute.
Yes,
Two
sir.
judgment has been cited. Well,
Yes.
if your lordship look to the Gajal Brothers judgment, my lord will find that Honorable Three Judges bench says when it is travelled to Delhi and it is granted leave, the order under appeal is erased. If it is erased, my lord, what is to be executed?
Right, we'll consider that. We have to consider it, we'll
And
consider.
the two single judges, the Kerala High Court judgment, other judgment cited with the Bhattacharya cannot have any overriding effect of the Supreme Court judgment.
Naturally.
That's all.
Right. Yes, sir. Just one sentence on the news.
Judgment shown.
Yes.
If my permission to read the order without carefully, this was an appeal from the punishment imposed under the contempt jurisdiction.
This issue was not decided.
Not decided. On the contrary, I would say that the jurisdiction is in fact affirmed. The Supreme Court didn't say that it didn't have any jurisdiction to impose punishment. Just without, and then without the another. Then,
If it did not decide the issue, then either side of the divide, it didn't decide.
I humbly submit to logically, this issue now has been affirmed by the Supreme Court that the contempt jurisdiction exercised was right. And then say the last line, we have been apprised by Mr. Dayal, learned counsel for the respondent, that the appellant had long been complied with the order. Taking note of the aforesaid, we are of the considered opinion that there is no justification to impose any kind of punishment on the appellants, and accordingly, judgment and order passed by the High Court as imposing punishment is set aside. If any proceeding relating to contempt is pending before the High Court, it shall be deemed to have been disposed of. The court doesn't say the High Court didn't have any jurisdiction even to entertain.
There is no occasion. There is no occasion to decide.
My lord, just kindly excuse me, my lord, for 1 second. Kindly excuse me, my lord. I am just seeing the only Mr. Saptangsu Basu's face, not the court. Now, my lord,
That is the technical glitch. That is the technical glitch we are talking about.
my lord, kindly see. My lord, kindly, just 1 minute. Kindly, my lord. I have argued. Kindly, this is kindly take note of that. I have argued that in the Supreme Court judgment, points were not left open. If the points were not left open, the question of deciding the question again does not arise in view of that judgment.
Very good. Heard learned senior advocates appearing for the LS contemners, full stop. Heard learned senior advocate appearing for the petitioner, full stop. Next part. Hearing concluded, judgment is served.
Now, Mr. Basu has managed something, therefore his face is coming down.
Sorry, please, Dada.
His hand is so long. His hand is so long. There he goes.
Same side হয়ে যাচ্ছে
সবাইকে ছেড়ে আমাদের
Grateful to again Saptangsu Basu's face.
Grateful to Dada also.
Also, no.
There were 3 matters.
Yes. আর অন্য দুটোকে করুন তো, অন্য দুটোকে রেকর্ড করে দিন তো। 8 and 9 separate orders করবেন। Since an issue of maintainability exists in this contempt petition, and since we heard the respective parties on such issue in an earlier in another contempt petition, it would be appropriate to direct the 2 contempt petitions to appear along with the CPN. But to direct the contempt petition to be listed on the date of delivery of judgment of CPN 612 of 2025. 621 of 2025. Same order in item number 9.
Poor woman, 563 days delay. Kindly continue. First appeal.
One thing I have correction out of the same judgment, I found there is one more convicted accused. That preferring the appeal.
7 days.
Considering the averments made in the application for condonation of delay and considering the quantum of punishment suffered by the appellant, we deem it appropriate to condone on the delay of 507 days, which the department reports, in making and filing the appeal. First of next paragraph 1 of 2020 is disposed of. Post of proper admission of appeal. We'll consider if and when there is an appeal.
Give your blessing.
Because if the earlier is because of public call for
That the department will know. Department will know.
Worship, I am for the appellant. Worship, judgment is of 31st January 2025.
ওই admission of appeal এর order হবে।
Deeply obliged.
I'll beg to appeal for the applicant, my lord.
Defect,
You can appeal against conviction.
defect.
My lord, Section 5 application has been filed. There is a delay of 1 year, 10 months. But this needs to be served to the victim.
Appellant will serve a copy of the application for condonation of delay as also the memorandum of appeal upon the respondents, including the victim, and file an affidavit of service to such effect on the next date, post of next part. List the appeal along with the connected application on May 15, 2025.
Well, 13 preferred by appeal on behalf of Salsa.
Again defective.
Yes, there is a delay 49 days.
Served. 49 department reports 49.
Right,
Yes.
Yeah, Section 5 is 49 days delay. And my lord, date reference.
She wants it to be in this thing.
Okay.
Not today will do.
As you lordship, please.
I don't know, you tell me.
Kindly name maybe given and admit.
PP will come here and start shouting.
I will talk with you.
No.
Today is closed 1st May.
PP's office is closed.
Yes. The state government. There is
You tell him that you go outside court and tell him that the court wants him here.
Yes, ma'am.
His office may be closed. How can PP be closed?
Name may be given to Mr. Onuswar. Miss.
Appellant is represented through legal aid. Post of next paragraph state is represented on Nam diye deben Tonuswar. Learned public prosecutor is requested to regularize the appointment of the learned advocate for the state. Post of next paragraph. There is department reports a delay of 49 days. Post of next paragraph. Considering the averments in the application and the fact that the appeal is through legal aid and considering the quantum of sentence imposed, we deem it appropriate to condone the delay. Allowed admission of appeal.
Admit the appeal and heard along with date reference 3 of 20.
Next paragraph. Court is informed that there is a death reference pending being DR 3 of 2025. List the present appeal along with the DR 3 of 2025. When is that coming up?
It will.
আজকে লিস্টে আছে ওটা কবে দিয়েছে
দেখো তো লিস্টে রেকর্ড কি আছে ওটা অ্যালং উইথ এলেই তো চলে আসবে হ্যাঁ তাহলেই চলে আসবে
13 and 14 is there. It is already with DR3.
অলরেডি আছে
হ্যাঁ
রেকর্ড নেই তো
তাহলে ওই লোয়ার কোর্ট রেকর্ডস এর এটা ডিরেকশনটা তো থাকবে
এই যে 3 of 2025
অ্যাডমিশন অফ অ্যাপিলের অর্ডারে কি লিখবো অ্যাপিল অ্যাডমিটেড আর লোয়ার কোর্ট রেকর্ডস লাগবে না তো থাকবে না তো বা শুধু অ্যাপিল অ্যাডমিটেড করে দে অ্যাপিল অ্যাডমিটেড আর ইন ভিউ অফ দি তারপর লিখে দে in view of the fact that one of the accused suffered death penalty and there is a death reference being DR3 of 2025 and since the records are to and therefore the trial court records are not called for in the present appeal.
ইয়ারে তো জানি না কি বলবো না না পেপার নিতে পেপার বুক দিয়ে
You are the person who suffered the death penalty.
Yes. This happened.
ठीक है. I'll correct that order.
Yes.
my lord advocate. Admission of appeal এর order করে দিন।
My lord. By order dated 11/2/2025 and 13/2/2025, it was suffered life imprisonment of 395 and 10 years of RI regular imprisonment for
Admission of appeal এর order করে দিন।
I'm for that. A
Defect
delay
of-
of 40 days
Sir,
and no, my lord. And earlier, my lord, one appeal has been filed is 19 of 2025. So jail appeal has been filed.
by the same appellant. What
I
to do?
think this is the defect, my lord.
What to do?
Can it be March or my lord?
Sure, but this is not the ground. An application will no. This is not the ground of defect. Only delay.
40 days delay. Well, I will-
51 days delay. Ashun. Appellant will serve a copy of the application for condonation of delay along with the contempt petition along with the memorandum of appeal upon the respondents and file an affidavit of service. You know? The side effect on the next date, first of next paragraph, place the application on May 15, 2025. In the original side, whenever I drafted a petition for condonation of delay, I used to write in the press, delay if any be condoned, without specifying the date. You people in the appellate side always put a exact figure and then you start. Now the department reports for 51, you have written 47 and your prayer is not couched in that manner that we can condone the delay of another 4 days. Why do you people, I don't know, beats me. Original side, I always used to draft delay if any be condoned.
Come for the appellant, lordship.
Admission of appeal এর order হবে।
Yes, lordship.
My lord, 19 and 20, appellant is preparing the statutory appeal against the impugned judgment that dated 9th April 2025 and order dated 10th April 2025 passed by learned judge 3rd Special Court NDPS.
19 admission of appeal এর order হবে।
19 and
Same order.
Yes, your blessing.
NIA appeal. NIA appeal. In
Please, your lordship, my lord, I am appearing for the my lord in
2 years. My lord, I'll keep it very short. It's a 302 matter. About 34 people were implicated in the FIR. The case is actually not of NIA, but it says that there was some bomb blast for which NIA took it up. But it would give you a minute. I don't think your lordship would need to see any paper. Though the paper is slightly bulky, the FIR started against about 34, 35 people. It was alleged that a group of people took one particular person belonging to a particular political party to a place, and then after that, that person was found murdered. In the 35 persons, but a police case, local police case started. I was arrested subsequently. But there was a charge sheet which was filed. The charge sheet was called in question. The charge sheet was called in question by this honorable court, and thereafter the matter was transferred to NIA. But the NIA continued with the investigation. The NIA also subsequently submitted a charge sheet. But the person died of a bullet injury. The person who died of a bullet injury. There's a person who's named who has died, a person who shot. That person has not even been implicated, and persons, we are in custody for 2 years, and we are a part of that mob. We are facing trial, my lord. I was seeking bail on this ground.
The stage of trial?
My lord, charge sheet has been submitted, trial has not started.
Charges framed?
Charges have not been framed.
at the stage of framing charge.
And not only that, my lord, few of the persons who were granted statutory bails by the lower court, my lord, that statutory bail was subsequently cancelled by the lower court itself. The propriety of that was challenged before this court. Same situation, same kind of persons allegations. That propriety was challenged before this honorable court. This honorable court had released these persons on bail.
Right.
Effectively, I'm on the same footing. This
Where
is
is
the
that
long and
order?
short of the story.
Where is that order of the coordinate bench?
Coordinate bench order, my lord. Sure.
My lord, so far,
What is the involvement of these petitioners?
my lord, petitioner's involvement is been there. My lord, I am referring to my lord's CD is being brought, my lord. My lord, this is the my lord flag mark for the lordship's consideration, my lord. The statements, my lord, of the protected witnesses and also my lord, other witnesses, my lord. And so far, charge sheet is and so far my learned
Give
friends,
me a second.
my lord.
The names have been redacted. Other names have been redacted. The reason why these names have been redacted is not known.
Sabur আছে
মনে হয় না না
Hiren Sabur. তো এই তো কিছু প্রেজেন্ট ছিল at the time of offense.
ডিফ্যাক্টো কমপ্লেনটা কে?
ছিল
ডিফ্যাক্টো কমপ্লেনটা কে? মহিলা
ছিল
না,
postmortem report, sir.
ডিফ্যাক্টো কমপ্লেনটা কে?
I'm sorry. The person, my lord, who died, my lord, was gunshot injury. One person were injured, and there was bomb blast also, my lord. My lord, the CFS.
Postmortem report.
Yes, yes, sir.
পোস্টমর্টমটা বার করো। পোস্টমর্টমটা কি কোনো মামলাটা?
This is এ করছে corroborate করছে version of the items.
Well, he's the last question. I have one submission before your lordship reads anything. I'm sorry, Malak. Possibly we would have to stall the hearing.
I can't read when it's not legible.
SCST Act matter.
Which one?
This one. They've given an SCST Act. So I think I need to serve the de facto complaint.
SCST Act was there.
Oh, Mr. Chatterjee is there. Oh,
Well, previously, my lord, this section was not incorporated when the writ petition was
Very
being.
good. Give us a legible copy of the postmortem report.
what was given to us? He's the last court.
পড়ে যাচ্ছে আমি করতে পারছি হ্যাঁ ঠিক আছে একটা ইনজুরি হয়েছে আর অন্য কোনো করোবরেট করছে কিনা দেখছি মাথার ইনজুরিটা দেখি সে
State charge sheet.
আচ্ছা সুজয়ের নাম কি ছিল এখানে দেখুন
That's what matter. SCST Act আছে চলো ওরা যখন অভিযোগ করতে না
Your sheet copy. Legal document.
Not enough charge sheet.
Oh, state charge sheet. কেন বাবা আসে না কেন বলুন তো?
হচ্ছে না, ওরা এতে কি পেরিয়ে গিয়েছিল স্ট্যাটুটরি পেল, তারপর ক্যান্সেল করেছে। ক্যান্সেলেশনটা আপিলে এসছে, ক্যান্সেলেশনের আপিলটাতে হাইকোর্ট বলছে যে ক্যান্সেল করার কোনো দরকার ছিল না, পোস্ট বেল মিসকন্ডাক্ট নেই, আর লেবার সেকশন যখন সাবসিকুয়েন্টলি অ্যাড করেছে সেটা ওদের নলেজ ছিল।
মনোরঞ্জন হাজরা not
স্ট্যাটুটরি পেল
যেটা mark
2 ইয়ার্সে আপনি আর্টিকেল করতে পারেন।
There's a particular portion that I've marked for your lordship.
Where's the charge sheet? I mean the postmortem report.
Postmortem what we had.
This is what you are handing out.
This is statement. But this
Where's
statement
the
is-
chart, postmortem report, sir?
For CT Miller, CT Miller being brought me. Now that's why we can refer it from, because there were two postmortem. One was by the state Miller, thereafter Miller, second time postmortem by the commanders. Because I asked for the.
These are the subsequent
They
postmortem.
are supposed to reach by this time.
But this is not the important one. This is the subsequent.
ফেরত দিয়ে দিন। Why is the case diary not available to us?
Yeah, Miller asked for the case diary, Miller, he's coming, Miller, on the way.
How long should we wait?
Sorry, Miller, we have already asked.
We are sorry that who's the person involved? Why is the case diary not available to the court?
On the way.
Where is the case diary coming from? Timbuktu,
From Newtown.
Newtown. Yes.
Sapurji, Newtown.
How far is that? আসুন। A case diary is not made available to the court when the appeal is taken up for consideration. Full stop, next paragraph. The highest official posted at Kolkata with regard to this investigating agency will submit a report in the form of an affidavit as to why the case diary was not made available to the court at the time of hearing. Full stop, next paragraph. List the appeal on May 2, 2025, when the report as called for be submitted.
But can I make one prayer, Mother? Would your lordship keep it on Monday, kindly?
At 2nd of May.
2nd of I want a card. এটা আপনাদের মনে।
Not I am for the petition, Amar. In this case, my lord, your lordship may remember that I had first shown your lordship that the memo of arrest was not in accordance with law, and the Supreme Court has quashed those proceedings. Now, my lord, in the reply to my application, the NIA has stated, my lord, that there are calls, CDRs, and a transaction of money. Well, these are the two allegations against me. Now, the case records, the call detail records were from January 24 to 2 days prior to the incident. Nothing after that. So the case record relates to that. Hey, sorry, man, I'm so sorry, man. I have taken morphine, so I'm in a little bit of a drowsiness, my lord. Please pardon me, my lord. For the pain, I can't just take the pain, my lord. I'm going again tomorrow to Coimbatore, my lord. It's becoming.
Matter to be done on any other date, you're welcome.
My lord keeps it urgent for a week.
For a week?
Yes.
On the
One thing, may submit to lord.
List the appeal on. Give us a date which is convenient to you.
Before fixing up, may I submit one thing, by this time, the subsequent development has happened, the accused person, from whose house, the huge recovery was made. I was telling before on the last occasion, he has been taken into custody on Monday, He is being interrogated, So would it be Lordship's pleasure, subject to your Lordship consideration, it is in progress, some, connections, larger conspiracy has been, established, prima facie, Would you Lordship? Kindly, if in 3 weeks time is filed, we can file a progress report, so for further investigation is.
My lord, 3 weeks will go to the holidays.
No, before holidays.
To give us a date.
14th, my lord, 14th, if it will be okay with it.
17th,
Or Saturday.
Oh.
Or whatever we say, yes.
21st, kindly. I'm sorry.
21st ki, chutti hoye be. That's a holiday day.
No, 23rd পর্যন্ত আছে তো।
Oh, বাপ রে বাপ, আমরা যা বলবো ওই
24th holiday starts from 24th.
কেটে দিন।
21st.
Learned senior advocate appearing for the appellant seeks adjournment on his personal ground for a period of 1 month, for a period of 1 week. Post of next paragraph. Learned advocate appearing for the NIA submits that further investigations are ongoing. Full stop. He seeks 3 weeks time. Full stop. Next paragraph. Prayer for the prayer made on behalf of NIA is opposed. Full stop. Next paragraph. In such circumstances, list the appeal on May 19, 2025.
কি করে এগুলো না বলবেন সিভিটা কবে থেকে বলে দিবেন Milord, we are appearing for the Milord NIA Milord. Only Milord, we want Milord at least Milord 2 weeks time to file a written response, Milord. In similar circumstances, Milord, the prayer for bail was one of the accused person was rejected by your Lordship, Milord. This is the copy of the order.
There is no question of admission of appeal in this.
No, Milord. No, that is Milord bail, Milord, in the form of appeal section 21.
Not a question of admission of appeal. Appeal is directed against an order refusing to grant bail.
No, I was released on bail. My bail was cancelled on the same points.
Oh, okay. Appeal is directed against an order of cancellation of bail passed by the jurisdictional court in a police case involving the National Investigating Agency Act 2008. Full stop. Next paragraph. Since the appeal is appearing for the first time today, it would be appropriate to permit the respondents one opportunity to file affidavits. Full stop. Next paragraph. Let affidavit in opposition be filed within 2 weeks from date. Full stop. Reply, if any, within?
In 1 week.
1 week thereafter. Full stop. List the appeal 3 weeks hence.
Date of framing of charges tomorrow. So I hope that will not be an issue.
It is clarified that, pendency of this appeal will not be cited as a ground for adjournment at the trial by any of the parties.
I only took this point.
Very good. By any of the parties.
I am for the petitioner. Yesterday, heard it. This is I file an application, original application before the tribunal for disposal of the my miscase, which is initiated for correction of record of rights. That by directing the authority to dispose of within 6 months, my lord. Thereafter, he has not disposed of. I file an contempt application. Contempt application rejected on the ground that I have not made communication.
Will ask the BLR to dispose of the proceedings.
He has initiated, my lord. On 6th, he has called these people for hearing, my lord.
Writ petition is directed against an order dated October 4, 2024, passed by the West Bengal Land Reforms and Tenancy Tribunal in MA 880 of 2024, OA 2068 of 2022. Full stop. Next paragraph. Learned Tribunal passed an order dated July 20, 2023, requiring the concerned block land and land reforms officer to dispose of the remand proceedings being number 3 of 2003 within a period of 6 months from the date of receipt of the certified copy of such order. Full stop. Next paragraph. Order dated July 20, 2023 passed by the learned tribunal was communicated to the concerned BLLRO. Full stop. Apparently, comma, the concerned BLLRO did not take any steps thereon. Full stop. Consequently, comma, the writ petitioner preferred a contempt petition being MA 880 of 2024 before the learned tribunal complaining of violation of the order dated July 20, 2023. Full stop. Such contempt petition was disposed of by the impugned order on the ground to that, comma, the writ petitioner failed to serve the copy of the order upon the concerned BLRO. Full stop. Next paragraph. Materials on record suggest otherwise. Full stop. Next paragraph. Be that as it may, comma, court is informed that, comma, the concerned BLLRO issued a notice dated April 30, 2025, fixing May 6, 2025 to dispose of the remand proceedings being number 3 of 2023. Full stop. Next paragraph. Concerned BLRO will therefore proceed to dispose of the remand proceedings being number 3 of 2023 within a period of 6 months from today. Full stop. Next paragraph. In such circumstances, comma, the impugned order dated October 4, 2024 is disposed of by permitting the concerned BLRO to by directing the concerned BLRO to dispose of remand proceedings number 3 of 2023 within a period of 6 months from date. Post up. Next paragraph. Learned advocate for the state will communicate to this order to the concerned BLRO for compliance. And this time, let them violate. Please come up again. And this time, we'll see how.
Careful.
On record.
Lord 25, Lord, I am for the repetition appeal and Lord, on previous occasion, my Lord heard this matter and directed the learned advocate for the respondent number 4, that is the collector, to recover the money which has been, Lord, given to the private respondent. Lord, the dispute regarding the, Lord, the sharing of the compensation of the.
Yes, sir.
See, already we have 17 lakhs 22,000 accounts in our hand, my Lord.
Yes. And how did you disburse? On what basis did you disburse?
Pursuant to the Justice Bag's orders, my Lord. Honorable Justice R.K. Bag's, my Lord. Page 98, my Lord.
Before that, disbursements were done, Lord.
And my Lord.
Page 98.
98, my Lord.
What are page 98, Ravi?
Of the stay petition.
And that was set aside by this Justice Bagh, my Lord. And
yes, respondent number 7 was directed to disburse share of compensation of the petitioners after giving the petitioners and the private respondents an opportunity of.
That was hard, my Lord. 104, my Lord. 103, my Lord. 103, my Lord. On the basis of this, my
They
Lord.
were present. This petitioner was present in the hearing.
Lord, I was present.
Yes, my Lord.
I was the petitioner, Lord, I was present. And Lord, the kindly see after the disposal of the my Lord Justice Bagh.
In the original award, my Lord, also 17
paragraph.
105, my Lord, last person.
104 last paragraph. The Honorable High Court has ordered to disburse the share of the compensation of the petitioner. That is Lord 33.33 according to their observation, their order. Lord, I will show the page 46. In that order, no specific percentage of the share of compensation has been mentioned. That is the order passed by the Justice Bagh, Honorable Justice Bagh. Share of the compensation which was originally awarded to the petitioner for the payment of is for 0.78 decimal of the land, which is 17% of the total acquisition land. That is the possession. In the original award, also the 17% share of the compensation was ascertained for the petitioner's group. The share of the group were 2099 decimal, that is the 45.42 decimal, 1.58 decimal, that is 33.33, and Lord the 0.15 decimal, so on, so on, so on. So next, very much important, 33% share of the petitioner is disputed.
By the other shareholders.
Was disputed the private respondent, whereas blood they have received their compensation. Blood because they have disputed, that is why they have.
File a suit and take it.
But the partition suit is pending. That is why my lord observed on previous occasion when you have you have withheld the share of myself. Why the share?
Because it was undisputed. Their share is undisputed. You did not dispute their quantum. Your entitlement in excess of 17% was disputed. That is why they withheld.
Kindly see the page 46, Lord. I am showing their own orders, Lord. Page 46, Lord. Kindly see, Lord.
We are not here to decide a title dispute.
That is not the title, Lord. They observe the what percentage of the share I have. That is
they have not decided the percentage of share of any of the parties. The state has proceeded on the basis of admissions. You claim 33%, it was not admitted, 17% was admitted, disbursed. They claim 45.42%, you did not dispute, they disbursed. So what's wrong? The balance is with them. You get the partition suit is still pending. You go and get your share declared, you'll get your money. একদম admitted position এ গেছে.
Lord, kindly see the page 66 of the statement. 17% share of the page 66, Lord. This is the undisputed Lord, the document, Lord. Page 66. Lord, the third column. My 17.2.
This undisputed position is in the partition suit. Go get it declared there. Why we cannot say this is admitted or disputed or whatever. This dispute appears at page 105.
Lord, they have not disputed when the order was passed by the collectorate.
That was set aside, man.
Lord, which was challenged in the first preparation.
That was set aside by Justice Boggs order.
The percentage kept reserved conditionally. The person can be disbursed to them
if
title of
33.63% is kept reserved conditionally. The 33.63% can be disbursed to them if the half 1/3 is decreed in the suit.
So it is subject to a decree to be passed in the suit. In fact, they should not have disbursed the 17% also.
On the other hand, Lord, they have given the disbursement to them, Lord.
Because that is admitted, you admitted it.
Lord,
that is the recording at page 105.
Lord, 105, Lord, I am reading for myself, Lord, we kindly see the 105. However, the 104 on Lord's latter part, however, the impugned order has been quashed. Hence, the decision of the impugned order has become inoperative and cannot be implemented. The Honorable High Court has ordered to disburse the share of the compensation to the petitioner. Lord, that was the observation of the Justice Boggs, Lord.
Ashun. Appeal is directed against an order dated February 29, 2024, passed in WPA 29187 of 2017 and WPA 29193 of 2017. First of next part. Appellants before us claim that they are entitled to 33% share in the money awarded in respect of an acquisition proceedings. First of next paragraph. In support of such claim, reliance is placed on an order dated September 5, 2017, passed in WP 10387 within bracket W of 2017, order dated November 6, 2017, passed by the competent authority as well as
additional district
an order dated March 22, 2017, passed in LA case in which the acquisition proceeding in respect of the acquisition proceedings. First of next part. State and the National Highway Authority of India are represented. First of next part. NHAI initiated acquisition proceedings for the purpose of acquiring land for a highway. First up, land belonging to the petitioners were acquired in the acquisition proceedings. First up, in such acquisition proceedings, an order dated March 22, 2017 was passed, by the competent authority where, a share of the petitioner was pegged at 33.33%. First up, it is such order specified that, such percentage of 33.33 is kept reserved conditionally and can be disbursed to them if title of 1/3 is decreed in that case for them. First up, next paragraph. There is a suit for partition with regard to the movable properties concerned. First up, such suit is yet to be decreed. First up, at least a preliminary decree attention of this court is not drawn to any preliminary decree declaring the shares of the respective parties in the partition suit being passed by the appropriate court. First up, next paragraph. A writ petition was filed with regard to the compensation receivable. First up, such writ petition being WP 10387 within bracket W bracket 1st of 2017 was disposed of by an order dated September 5, 2017, requiring the authorities to disburse the share of compensation to the appellants after giving the appellants and the private respondents an opportunity of hearing. First up, next paragraph. Competent authority thereafter, initiated proceedings for the disbursement in terms of the order of the High Court dated September 5, 2017. First up, competent authority passed an order dated November 6, 2017, where, the competent authority noted that the shares of the private respondents were undisputed and that, claim of 33% share made by the appellants were disputed. First up, the such order, however, records that the claim of the appellants to the extent of 17% were admitted by the private respondents. First up, in view of such admission, competent authority proceeded to disburse 17% of the compensation amount to the appellants. First up, the balance amount is kept with the appropriate authority, subject to the decision that may be rendered by an appropriate court. First up, next paragraph. As noted above, the partition suit is yet to be disposed of. First up, there is no pronouncement brought on record of any competent court declaring the exact share of the appellants in respect of the property concern. First up, next paragraph. Learned single judge therefore, rightly directed the appellants rightly disposed of the writ petition by granting liberty to the appellants to accept 17% of the compensation as offered by the respondent authorities without prejudice to their rights and contentions, with liberty to the appellants to claim further compensation commensurate with their share in the plot in question, subject to the result of the partition suit. First up, next paragraph. We find no ground to interfere with the order impugned. First up, next paragraph. Mat such and such along with connected applications are disposed of without any orders to cost.
Grateful, my lord.
Same problem.
That private respondent, my lord, was informed yesterday the encroachment was removed by the authorities.
We can dispose of the appeal. None appears for the appellant and the other respondents apart from the you're appearing for?
Private respondents.
Apart from the private respondent, first of next part. Learned advocate appearing for the private respondent submits that the encroachment stands removed. First of next paragraph. In such circumstances, who's appearing for the state in this matter?
Lordship, I am appearing for the state, but Lordship, I came to know that I am not briefed in this matter, Lordship. On the last occasion, by mistake, I appeared, Lordship. I tender my unconditional apology, Lordship.
Who was allotted this brief?
My lord, I was not allotted, Lordship. By mistake, I appeared before your Lordship.
You know? Can 1 MAT such and such along with Can 1 of 2025 are disposed of.
Great.
Very good, Lordship.
Section 5 is required. Out of time. Achha, there is a section. Yes, sir. No encroachment found.
Yes, my lord. What happens only, my lord, I am praying, why I am praying before your lordship? Lord, the petitioner before your lordship is a widow. What happens, my lord, this shop room has been constructed by her late husband. Now, what happens, my lord, if your lordship kindly see the picture, my lord, only 1 foot 6 inches I have been, my lord, as per the record, my lord, 1 foot 6 inches. But thing remains that they have constructed the waiting room for bus stand. My lord, I cannot enter in my shop room. If your lordship kindly see the 3 pictures, your lordship kindly see. I'm even not in a position to open the door. I can also, my lord, demolish my part which I have been encroached. But your lordship kindly see that I cannot enter into the room.
But they have not constructed on your property.
Yes, my lord, that is true, my lord. They can, my lord, they constructed, my lord, as well as my lord, no, at that time, my lord, there is no, my lord, permission from the authority.
This
that is true.
construction cannot be said to be illegal. A public
Because-
land, a public authority constructed on public land. Now, that construction may or may not affect your
But your lordship, kindly see the, if they some totally blocked, I cannot enter, my lord.
Maybe, but we can't help you.
If that is, my lord, 1 foot, I can demolish my part, my lord. So 1 foot 6 inches, because it is long before, my lord, this ghar was, my lord, constructed. My lord, at that time probably, my lord, some mistake has been taken place. If they can also, my lord, some way, my lord, that part only, my lord, 1 foot or 2 foot, then I can enter into my room, and I can also, my lord.
Shop room?
Yes, my lord.
What is your shop room?
Stationary. And my lord, this is my only, my lord, livelihood.
Can't be helped, sir.
That's why, my lord,
ও পছন্দ হচ্ছে না, পুরো ফ্রন্ট টেস্টে চলে গেছে, ও দোকানে বিক্রি বাটা বন্ধ হয়ে যাবে। কি করে নেবো আমরা?
Even I cannot open my door.
আমরা তো কিছু, এটা তো ওভারওয়েলমিংলি পাবলিক ইম্পর্ট, সেটা তো বলতে পারবো না যে পাবলিক ইম্পর্টেন্স নেই বা পাবলিক পারপাস নেই।
But if it is somewhere, some 1 foot or 1 foot half inches,
You
they
came
can.
too late. You came too late when the construction was made.
My lord, I have given an objection. If your lordship kindly see
Now
the
it's too
objection.
late in the day. We can't, sir. This is for a public purpose, undoubtedly.
Yes, my lord.
Then what can we do?
In that case, my lord, I have no objection, my lord. For the purpose of making the construction, my lord, I have no objection.
In fact, you encroached on public land.
Yes, my lord, I know, my lord, that after the demarcation I have seen.
Then? করা যাবে না, জঞ্জালের
Only the, my lord, the stairs, the ground portion, the shop room is not.
জঞ্জালের জায়গাও তখন রাখা যাবে না, ভ্যাট রাখা যাবে না, কারো বাড়ির সামনে কিচ্ছু রাখা যাবে না। আবার কে কার বাড়ির সামনে রাখা যাবে না? যে এনক্রোচ করে বসে আছে। আসুন। Can 1 of 2025 is an application for condonation of delay, full stop, next paragraph. For the ends of justice, comma, considering the averments meeting such application and the quantum of the delay, we deem it appropriate to condone the delay in making and filing the appeal, full stop, can 1 of 2025 is allowed, full stop, next paragraph. appeal is directed against an order dated May 2, 2025, passed in WPA 20606 of 2023. First up, next paragraph. By the impugned order, learned single judge found that, on demarcation at the local, it was found that, the public authorities did not encroach upon any land belonging to the petitioner. First up, it is the other way around that the petitioner na kore appellant. It is the other way around that the appellant was guilty of encroachment on public land. First up, next part. At the hearing of the appeal, it is contended that, there's hardly any space between the construction made on public land and the shop room belonging to the appellant, who is a widow. First up, it is suggested that, if, the construction on the public land can be shifted by 1 foot and the appellant demolishes its structure with regard to the quantum of encroachment, then, at least, the shop room will be functional. First up, next paragraph. With respect, we are unable to accept the suggestion advanced on behalf of the appellant. First up, firstly, appellant is guilty of encroachment and not the public authorities. First up, moreover, moreover, secondly, the construction made is by a public authority on a public land without encroaching upon any land belonging to the petitioner. First up, the construction is for a waiting hall for passengers on a road. First up, the construction cannot be termed not to be for public purpose. First up, next paragraph. Learned single judge took pains in ensuring a demarcation being made at the locale. First up, demarcation of the land in question as well as the report establishes that, the the public authorities did made such construction for public purpose on public property. First up, next paragraph. In such circumstances, we find no ground to intervene in this appeal. First up, MAT 518 of 2025 is dismissed without any orders to cost. It cannot be said as a appellant cannot be appellant is also not claiming any right, title, and interest over the area on which the construction of the waiting hall was made by the public authorities.
This is my review petition. My lord, I have one accommodation, one request for an accommodation, my lord. An application is to be brought, my lord, to modify the heirs of the petitioners number 17 and 18. My lord, the person who is competent to make the application, my lord, is not in town, my lord. If this may be taken up, my lord, at any other time, my lord, is, if I may be given a week or two, my lord, to...
On the prayer made on behalf of the review applicants, list the review on May 13, 2025.
Grateful, man.
That's good. I have for the appellant, I'm not sure so the respond.
Who's opposing you?
But I'm not sure. Old matter. I may give a notice to them. Yes.
Please send your junior to the GP's office is closed today.
So I'm not sure.
To find out whether who's been allotted this brief.
But,
who appeared for the state, Mrs. Chaitali Bhattacharya is no longer in the panel. Mr. Supriyo Chattopadhyay, Miss Iti Dotto, either of them, please.
But can you keep it up next week? In the meantime,
give me a second.
Yeah, Supriyo ko jayega.
Why should we break our head? Dead and Deadwood, 2007 selection process, 2017 writ petition. Then
That's why I have been selected. I have been working. Now the learned judge says that selection should be done afresh following school service commission, which was not the issue, which shouldn't have been gone into. I've been allowed to continue, but then since it should be now vacancy should be declared as a SSC selection procedure, which is unwanted. Nothing has been done, of course.
there are two defects noted in the memo of appeal also.
2019 to the defect recure put there.
Ashok. The appeal is specially assigned to this bench by the Honorable, by an order dated April 25, 2025 of the Honorable the Chief Justice, first term, next paragraph. Department reports defects with regard to the appeal, first term, next paragraph. Learned advocate on record for the appellant is granted leave to remove such defects, first term, next paragraph. Appellant will inform the respondents as to the pendency of the present appeal and file an affidavit of service to such effect on the next date, post term, next paragraph. Lest the appeal on May 13, 2025.
May 13.
State respondent.
My lord, in this matter 31 and 32, my lord, Parthasarathi Bhattacharya is engaged, my lord. He could not come today. I am praying for one day.
Not today.
My lord, I am appealing on behalf of the appellant. My lord, in this matter, my lord, your lord was pleased to, my lord, on the matter on the last date, my lord's pleasure was to, my lord, for the, my lord, these affidavits have been prepared.
Give us
affidavit. Yes.
We do have service paid.
My lord.
Give me a second.
Yes.
Have you given him a copy?
Yes. Is replica of the earlier ballot affidavit.
Very good. Bosun. Bosun. Yes, sir.
My lord, this affidavit has been filed, my lord, and it says, my lord, that as the admissible dues, my lord, has already been paid, my lord, there is no further admissible dues on our part to be paid, my lord.
Very good. What do you say?
I say that, my lord, without quantify the, my lord, loss, they cannot deduct the gratuity.
Second thing, there is no moral turpitude on the part of the appellant, my lord, if your lordship see the order.
He said admitted dues. So they are not admitting any dues. Your contentions with regard to gratuity receivable and everything else is a point of contention which need to be decided. They, from their point of view, they are not admitting any amount to be payable apart from whatever they have paid. Now, you show us that there is any admitted dues. Admitted meaning uncontested dues.
Well, so far our contention is, well,
then we'll hear the appeal. Yes, sir. Please proceed with the merits of the appeal itself. Sir. Yes, sir.
my lord, our first contention is, my lord, the relied documents along with the charge sheet was not supplied. Second, my lord, the inquiry officer had acted as a prosecutor, though he had to act as an independent adjudicator. And inquiry officer believe and disbelieve the same witness at the same time. And my lord, inquiry officer traveled beyond charge sheet and adduced new charges in finding, though no inquiry was held on the basis of the said charge, and the prosecution to prove, and he was invited the prosecution to prove the charge. Employee need not disapprove the same. And MW1 was the credit officer during his tenure. The appellant and all the credit decisions are routed through our desk, and the management witness herself is the guilty of negligence. And appellate authority, without applying its independent mind, has passed the order in a cryptic manner. So far the order is concerned, there, though he was removed, but one, there is a rider that he may be appointed in future. That means there is a modicum.
Where's the charge sheet?
Charge sheet is at
page 82.
80.
Where is your letter requesting for documents? Page 101. This is a letter dated 24th of January 2014. Any meeting subsequent thereto?
24th January. Thereafter, my lord, again, my lord, I've given them reminder 102 also.
Page 103 is the minutes.
Yes.
Then what happened? It was complied with.
103, and thereafter, my lord, again.
So thereafter, did you complain of supply of documents?
Thereafter, my lord, proceeding
So the page 103 says that all documents to be submitted before 15th of February 2014, right? You were given those documents because they are subsequent thereto. You did not continue with this allegation of non-receipt of documents.
with the charge sheet, no documents has been supplied to.
It was given subsequently. You have raised a point, then
that,
they have given it to you. Before the commencement of the inquiry, evidence been recorded in the inquiry, you had all the documents, right? Wait, then there's no point. Then what else? The inquiry officer acted as a prosecutor. Where's the inquiry report page?
One to six. Inquiry.
Page 1 to 6.
Start from 1 to 7.
1 to 7. Where's the disciplinary authorities order page? After inquiry report, you were given a show cause.
Yes.
Where's that show cause notice?
No second.
No second show cause notice. Where's the disciplinary authorities order?
183.
183. 183. What's wrong with the inquiry officer's report?
193 kindly see, penalty made.
Page 1?
193.
One.
Exercise of power conferred upon me by regulation 5.3 read with regulation 4 and 7 of the Bank of Baroda officials employees discipline and appeal regulation 1996. I hereby order as follows: in exercise of powers conferred upon me by regulation 5.3 read with regulation 4 and 7.3 of the Bank of Baroda officials discipline and appeal regulation 96, I hereby impose the following punishment on Mr. Ranjan Bandyopadhyay: removal from bank service, which shall not be a disqualification for future employment.
You get take any employment anywhere you want to, including the bank. It doesn't mean that they'll have to give you future employment. What else?
That means, my lord, there is a no moral turpitude on the part
Maybe,
of.
may not be, not an issue. No moral turpitude. So,
therefore, if there is no moral turpitude, therefore they cannot withhold my gratuity, my lord. Gratuity and other other benefits such as leave salary and.
where are you getting that? No, because of no moral turpitude, gratuity cannot be withheld. Under what provision of law?
So far the moral turpitude is concerned, kindly see that section 4 of the Gratuity Act says that only on this particular ground the gratuity must be withheld. Otherwise, one cannot. Section 4, my lord, kindly see. Section 4 of the Gratuity Act. Payment of gratuity. Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for less than 5 years, on his superannuation, on his retirement or designation or resignation, or on the death or disablement due to accident or disease, provided the completion of continuous service shall not be necessary where the termination of the employment of any employee is due to the death or disablement. Provided further that in case of death of employee, gratuity payable to him shall be paid nominee or no nominee. Second, every for the
Mintu, payment
notwithstanding anything
of Gratuity Act.
Gratuity Act. Payment of Gratuity Act.
Check. Section 4, subsection 6. Notwithstanding anything contained in subsection 1, the gratuity of an employee whose services have been terminated for any act, willful omission, of negligence causing any damage or loss through or destruction of property belonging to the employer shall be forfeited to the extent of the damage or loss so caused. Here, my lord, there is no quantification. B. Gratuity payable to an employee may be wholly or partially forfeited if the services of such employee have been terminated for his riotous or disorderly conduct or any act of violence on his part, if the services of such employee have been terminated for any act which constitutes an offense involving moral turpitude, provided such offense is committed by him in course of his employment. There are two conditions.
Finding if you are terminated for any act, willful omission, negligence causing any damage or loss,
Yes,
then gratuity is not receivable.
Then damage should be quantified.
Right. Come to page 192. Lapses of the CSO charged of.
Lapses of CSO are serious in nature. It is observed that in performance of his official duties and in exercise of power conferred on him, he had unauthorizedly exceeded his authority and powers and did not report them and or obtained approval and confirmation from higher authority for his such action. He has sanctioned and disbursed credit limits in violation of the bank's rules and established procedure. He had exhibited casual approach and gross negligence in discharging his duties at each stage, and be pre-sanctioned, sanctioned, disbursement or monitoring level, his action resulted in fraud being perpetrated in advance account of Messrs. Komala Auto Stores. His irregular action have had a contributory effect to the causing of potential loss to the extent of 420 lakhs, 0.56 lakhs loss on account of fraud perpetrated. That how my loss has been sustained, that has not been calculated.
Calculated. Upheld by the appellate authority.
There is
192. Seventh arrow from the top. Without ensuring margin money, vehicle loan disbursed, distributor such and such, amount such and such. Quantum is there. A number of quantums are there. Different bank accounts given.
And my lord, it is a consolidated decision.
There is a valuation of property. Go on. W working capital demand. WCDL. I don't know the full form. Sanction for 230 lakhs, but disbursement for 236, exceeding sanction limit.
So far, the loan sanctioning is concerned, it is not the sole decision of the appellant.
You are also a person engaged in the decision making process. Right, just there are 5 murderers. Just because one got caught, can't say that the 4 others not got caught. I need to be left out. Sorry, sir. Sorry, sir. The quantification is there. Then what else?
My lord, I am a so bad person. Then there is no question of re-engagement me.
They have not asked you to be re-engaged. All that they said that this order will not prevent you from receiving future employment. Anywhere elsewhere, you can go and get your, that is not an order of stigma. That is all that they have done. You want us to remove that? We'll do that also. We can show that removal from service will be a disqualification for future employment. We can do that. They have permitted you to get an employment wherever you can.
I've already reached the age of superannuation.
So bad for you. We can't be assisted. We are not aware of any age reversal mechanism. If you have that expertise, share with us. What else? Plausible view নিয়েছে, আমরা তো উল্টোতে পারবো না। Detail উল্টে করেছে।
Kindly see that WCDL sanctioned for rupees 230 lakhs, but disbursement was
236 lakhs. You exceeded by 6 lakhs without sanction. Good enough. Bus conductor got his job terminated, upheld right up to the Supreme Court because poor gentleman could not match one.
15 rupees or
Not rupees, paise.
40 paisa. 40 paisa.
My lord, disbursement is 230 so far my client says, and it is
Sir, this is the record. We cannot say that this is perverse. It is detailed. You may not agree with it. So bad for you. Appellate authority upheld it. Writ court upheld it. Too bad in the day. Too late in the day for us to intervene. We cannot go about town reappreciating the entire evidence. That's not our job. We need to see whether there is any breach of principles of natural justice, any misconduct in the inquiry proceedings, order is perverse or not, excess of jurisdiction or not. None of this appears.
And Malutali, one thing you will also kindly see in the 105 for a moment in the cross examination, management witness answer nothing. Kindly see. Can you tell?
The inquiry officer evaluated so many prosecution witnesses in details. In details, he has taken a view which is a plausible view. We can't say no, this view is wrong. We may not agree with him, but again we need not substitute our own finding. We are not called upon as a court to substitute our finding. We are not the appellate authority. Ashu.
So far, 230 has been sanctioned. 6 lakh is so far the interest is concerned.
Maybe, but that is a view taken by the authorities, disciplinary, and it is not limited to one defalcation. Whole lot. And they are saying that you were lax in your monitoring from pre-sanction stage, sanction stage, disbursement stage, and monitoring stage. And it is not only one account, they have given so many accounts. Appeal is by the writ petitioner and directed against a judgment and order dated August 10, 2023, passed in WPA 29790 of 2016. First up, next paragraph. A report in the form of an affidavit called for by us filed in court be taken on record. First up, next paragraph. Learned advocate appearing for the appellant submits that the appellant was not served with the documents along with the charge sheet. First up, he submits that the inquiry officer acted as a prosecutor. First up, inquiry officer proceeded to disbelieve and believe the same witness of the prosecution. First up, inquiry officer acted beyond the charge sheet. First up, he points out that the prosecution could not prove the charges leveled as against the appellant. First up, the next paragraph. Learned advocate appearing for the appellant seeks to draw us, took us through a portion of the deposition of one of the prosecution witnesses and submitted that such prosecution witness was a credit officer. First up, he also drew our attention to the findings returned by the inquiry officer. First up, he submits that since the inquiry officer recommended removal from bank service. He submits that, since the disciplinary authority, imposed a punishment of removal from prime services, a service which shall not be a disqualification for future employment, comma, the appellant should be considered for future employment. Poster. Next part, learned advocate appearing for the appellant submits that the order of the appellate authority is cryptic without dealing with the grounds raised in appeal by the appellant. Full stop. Next part, learned advocate appearing for the appellant submits that, comma, since, comma, no quantification of any amount was made by either by the inquiry officer or by the disciplinary authority with regard to alleged loss and damages allegedly suffered by the employer, comma, withholding of gratuity under section 4 within bracket 6 bracket post of the Payment of Gratuity Act, comma, 1972 does not arise. Post. Next part. A bank is represented. Post. Next part. Appellant before us was an employee of the bank. Post. A chart sheet as against the appellant was issued on
11 September 2013.
September 11, 2013.
And there
post
are two other addendums also.
Appellant was working as the senior manager at that material point of time. Post up. Appellant was allowed to file written statement with regard to the charges leveled as against him. Post up. Next part. Subsequent to the receipt of the charge sheet along with the articles of charges, comma, appellant, comma, wrote to the inquiry officer claiming that, comma, documents of the prosecution was not supplied to him. Poster. Such complaints appear from the writing dated February 16/17, 2014, and Poster. Next part. There is an order sheet of the inquiry officer dated February 6, 2014, which directs the documents to be supplied to the appellant. Poster. There is no subsequent correspondence at the behest of the appellant stating that, comma, the documents directed to be supplied, comma, were not supplied to the appellant. Poster. Next part. Disciplinary proceedings. Next part. In the inquiry proceedings, comma, appellant participated. Full stop. In order to bring home the charges as against the appellant, comma, prosecution relied upon prosecution examined various prosecution witnesses as also relied upon various documents. Full stop. Appellant adduced any evidence in the disciplinary before the inquiry officer. The
witness were exhibited.
only management, no defense witness. You बोल लो. The inquiry officer, comma, thereafter, comma, submitted a detailed report dated. Inquiry report is dated.
Hello?
Inquiry report is dated.
Inquiry is report dated. It is wrong. 9/6/2014.
June 9, 2014. Poster. Inquiry officer concluded that, comma, concluded that some of the allegations leveled as against the appellant were not proved. First up, he took into consideration, comma, the evidence led in the inquiry, as also both on account of the articles of charges initially framed and thereafter, comma, the added articles of charges. First up. First up. Inquiry officer in his reports stated that, the allegations with regard to the added articles of charges dated to December 13, 2013 is likely to result in a potential loss of 31.84 lakhs to the bank, Foster. The inquiry officer also stated that, out of 17 allegations, 5 allegations were partially proved, 12 were proved, and allegations added articles of charges dated October 19, 2013 were partially proved, and the allegation by added article of charges dated December 13, 2013 was not proved. Post-op. Next paragraph. Inquiry officer in his report dated June 9, 2014 opined that the appellant did not discharge his duties with devotion, diligence, and committed such omission which showed lack of care, caution, and reasonable judgment. Foster, gross negligence stood proved. Foster. He was also of the opinion that, performance of the official duties of the appellant were derogatory, prejudicial, detrimental, and injurious to the interest of the bank. Foster, appellant knowingly and willfully violated bank's rules and established procedures. Foster, appellant committed serious violation of duty, breach of trust, and misuse of office. Foster, actions of the appellant were unbecoming of an officer. Foster. Next paragraph. Disciplinary authority considered the inquiry report and by an order dated 15th of November 2014. November 14, 2014 was pleased to pass an order of removal from bank service, which shall not be a disqualification for future employment. Foster. Essentially, disciplinary authority concurred with the view taken by the inquiry officer, after discussing the nature of the allegations, the evidence found by the inquiry officer, and the conclusions arrived at. Post-op. Next paragraph. Appellant being aggrieved by the decision of the disciplinary authority dated November 14, 2014, preferred an appeal therefrom to the appellate authority as provided under the service rules governing the appellant. Post-op. Next paragraph. Appellate authority, by a decision dated
August 8, 2015.
August 8, 2015 was pleased to dismiss the appeal. First up, in doing so, appellate authority dealt with the grounds of the appeal, including the nature of allegations, the evidence found by the inquiry officer, decision of the disciplinary authority. First up, next paragraph. In inquiry report, order of the disciplinary authority as well as of the appellate authority are detailed. First up, it discusses every aspect raised by the both by the employer and the employee. First up, next paragraph. In the facts and circumstances of the present case, we are not in a position to subscribe to the view that, the inquiry officer acted as a prosecutor. First up, inquiry officer allowed the proceedings to take place and the parties to lead evidence as desired. First up, inquiry officer proceeded to evaluate the evidence placed before him. First up, he came to a finding as noted above, that some of the articles of charges were either proved or partially proved or not proved at all. Full stop. In doing so, as noted above, he evaluated the evidence of all witnesses. Full stop. He chose to believe or disbelieve such portion of the evidence of the prosecution witnesses and gave reasons for the same. Full stop. Next paragraph. A writ court is not called upon to evaluate the evidence and to substitute its finding with that of the inquiry officer or of the disciplinary authority or of the appellate authority. Poster. In the facts of the present case, or the three of the authorities prior to approach to the writ court being made, assessed the materials on record and arrived at cogent findings, giving reasons for the same. Poster. Next paragraph. Learned single judge, did not find any merits in the writ petition filed against the order of the disciplinary authority as well as of the appellate authority. Foster. Next paragraph. So far as payment of gratuity is concerned, we find that, the disciplinary authority, the inquiry officer in its report quantified certain losses that the employer faced due to the delinquency of the appellant. Disciplinary authority also proceeded to quantify such losses suffered at the behest of the appellant. Appellate authority concurred with such view. Next paragraph. In such circumstances, appellant forfeited his right to claim a gratuity in view of the provisions of the Payment of Gratuity Act, particularly Section 4 thereof. Next paragraph. We find no ground to interfere with the impugned order or impugned judgment and order. Next paragraph. MET such and such along with connected application, FMA such and such along with connected application are dismissed without any orders to cost.
Obliged, Your Lordship.
My lord, 34, 35, my lord, Mr. Satyajit Talukdar appearing on behalf of.
On the prayer made on behalf of the appellants, lists the appeal in the monthly list of June 2025.
In this matter, I appear for the respondent number 2 and 3.
Lord, I am for that.
3 and 4, my lord. My lord, this copy of the memorandum of appeal along with the stay application I have received just half an hour back from my client, my lord. They have scanned it and sent it to me through WhatsApp. But only I am praying in accommodation of a day, maybe.
Yeah, very good. We'll grant you that. Supposing we are pleased to dismiss the appeal now, you still require an adjournment.
No.
Very good. Yes, sir.
Lord, whether the writ petition is maintainable or not, this is the only law point.
Where is the certified copy?
Lord, certified copy, Lord, I filed this appeal with the.
You obtain the. Yes, you have to file the certified copy in the department, and then the question of limitation will arise on filing of the certified copy.
Yes. Well, yesterday I got it, my lord. I will file it in the
petition. Who's the appellant before us? The writ petitioner.
My lord.
You claim that there is a contract and there is a violation of such terms and conditions of the contract. These are disputed questions of fact.
No, but this is not the case in the writ petition.
Then what?
But what's happened, my lord?
You have a money claim.
No, my lord.
Then?
The respondent authority claimed money from me. My lord, on 13th of January 2015, my lord, tender was floated. And that agreement executed on 19th of March 2015. And in the agreement, only 4 months is allowed to me to execute the work. And Lord, in 2015, work had already been completed. Lord, entire payment had already been made to me. My bank guarantee is released. But after 8 years, Lord, they issued a notice that third party inspection to be there, which is beyond the agreement. And after that, my lord, page 101 is the under challenge in the writ petition. They are claiming you refund back rupees 586 lakhs to me because your there is some defect is found in your work. My only humble submission is, my lord, after 8 years of completion of the contract, and my lord, how can they claim the money from me after 8 years?
देखो 102 টা দেখুন 101 টা
But there is no serious disputed question of fact is involved.
Where is clause 27?
My lord?
Clause 27 of the general conditions of contract.
Clause 27.
They have referred to clause 27 of the general conditions of contract.
Not
Not annexed.
That is not on record, my lord.
Not an.
We just have one page. Page 77.
That's provision.
Who are you?
Because I'm appearing for the union. Because I appeared for the Victoria Memorial Hall for the learned single judge. That's page 77 is the agreement, my lord, article 5. If my lord goes on the point of jurisdiction, the laws applicable to this contract shall be laws enforced in India.
That doesn't oust to the 226 court.
It's not.
Lord, kindly have a look at
And
page
then
It is arising, the dispute now, the 8th November 2024 letter arises out of this agreement.
So the Delhi, no part of the cause of action arose in Delhi. For Delhi High Court to assume. Very good. So we and 226 jurisdiction is not cannot be ousted by agreement. Notice of default.
And we'll kindly have a look into page 76.
Who's NBA? Who's the employer? NBAFC?
NBCC, National Building Construction Company Limited. I am
bring that clause 27, general conditions of contract, also on the next date. 8 years ago, project completed.
No, my lord. The thing is that this is with regard to the upgradation of the electrification in the Victoria Memorial Hall.
Very good.
Victoria Memorial Hall Authority.
When did the project got completed?
In 2015-16, my lord.
And what year is this?
2025, my lord.
And you will.
My lord,
there is a defect liability period for 10 years.
My lord, the defect was detected by a third-party agent who inspected the work at the instance of Victoria Memorial Hall Authority.
Take any electrician to your house, a certified electrician, ask him to do the work, and thereafter take a second certified electrician to your house. If he doesn't find fault on the first work, you come back and tell me.
My lord, I understand that.
Yes,
my lord,
thank you so much. For 10 years, after 10 years, after 10 years.
My lord, kindly allow me 1 day time, my lord.
We'll give you time. We want to see that clause 27. And as of now, I'm very tempted to have an interview with that author of that document at page 101. I'm just restraining myself for the present moment. Give you time.
Or in that event, let me file an affidavit to this.
We will proceed on the basis of the trial court records. So no person gets to introduce any document in appeal. Whatever the learned trial judge looked into, will consider that only.
And then let me produce the general cause of contract.
We are asking you to do it.
Yes, my lord.
It's an admitted document. He's also admitting it. Show us you have invoked clause 27 after 10 years. Under what provision of law is something which I need to understand.
My lord, the thing is that we ourselves did not introduce it.
No. You have to, you are an Article 12 authority.
Yes, madam.
So you show us that clause 27 is available to you after Job Chanok left India. No issues. On the next, appellant will submit the certified copy of the impugned order in the department. Full stop. Next paragraph. List the appeal along with the connected application on May 14, 2025. Section 5 may be required.
Grateful, madam.
Grateful, madam.
Third party third party.
37 is my appeal, Malad.
Ma'am, for the respondent.
Malad,
For respondent number 1.
the impugned order directs that an acquisition proceeding be initiated and compensation be paid in terms of the 2013 Act. Your Lordship had been pleased to take up the matter yesterday, Malad. And Malad, as I have been instructed, Malad, Your Lordship had asked my learned junior to consider the indoor development judgment, Malad. But Malad,
applicable.
Malad, it won't be, Malad. Here,
it's not applicable, will not do.
Acquisition has not taken place at all. The process has not started at all. This is the scenario here. But we are up in appeal with your Lordship, Malad, for the limited point that Malad, we are not in a position to initiate proceeding under the 2013 Act. And I am sure, Malad.
How can that road come to be built?
Malad, road has been built.
That has been
Road has been built. Road is in use.
Then how? There will be an LA proceeding. How much? Your client is not. Where's the certified copy?
Certified copy nahi. Department number to. But my instruction is that it has been filed. One of the consistent finding of the Honorable Single Judge.
It is, sir, there is a road functioning. There will be an acquisition proceedings. Has to be possession made over. They won't get that possession. You are NHI.
No, my lord. Border road organization.
আরো ওয়ার্স ও তো এমনি নেবে না এনএচআই তো লাপি ঝাঁপি নিয়ে নেয় Where's the certified copy?
But it has been filed.
Filed where? Ganges?
Department. Malad, there is a online recording thereof, Malad. It has been filed on 11th of April 2025.
What date of the impugned order?
Malad, 27th of June 2023.
Order
correction, but it has been corrected subsequently.
2023. So there is an issue of limitation.
Malad,
there is one
filed on
contempt petition also.
There is an issue of limitation.
Correction, at a modification application. So there was a modification application by us.
Very good.
At that time, there was no bifurcation of Darjeeling district. This is falling in the Kalimpong district.
Very good. So last order is dated 8th of November 2024.
2024.
With the certified copy filed in the department on
11th April 2025.
So then, on the face of it, limitation.
11th of April 2025.
Yes, so therefore on the face of it limitation.
Malad,
leave was granted on 9th of December 2024.
Yes.
Yes, so you'll have to explain the delay.
Okay. I'll just check the Malad timeline.
Any event on the date you have to explain up to the date of filing of the certified copy. Those are your grounds for condonation.
I got it. 26th November 2024 it was applied for.
Those are your grounds for condonation. You'll have to file an application for condonation, we'll accept, but you have to file one.
Kindly keeps it next coming Thursday, madam.
The department reports delay in filing the appeal. Full stop. Next paragraph. Appeal was filed without the certified copy after obtaining leave. Full stop. Next paragraph. In court, comma, it is submitted on behalf of the appellant. That certified copy was filed in the department. Full stop. Next paragraph. Department will report as to the delay, if any, in filing the appeal. Full stop. Next paragraph. List the appeal on May 13, 2025.
Sir, may I have your lordship leave to look at the stamp reporter's report?
Yes, sir. Here, take it. But stamp reporter's report will not be there till such time this goes down and
Department of Judgment.
file an application before 13th of May.
So far, my understanding, my lord, that case is squarely applicable here, my lord.
Indore is applicable. Possession was given to you. Bring those documents.
I have.
Very good. Now, the 2013 Act will not apply.
Well, I filed an application before the SKO took hearing, said that there is no restriction that the minor also can granted the patta. Thereafter, I filed an application before the district land reform officer. He affirmed the order of the SKO. Now, challenging the order of the district land and land reform officer, I filed an OA application before the.
Who's the owner? Patta can be given in respect of land which is vested. So are you the owner?
I mean, my grandfather is the Borgadar of the subject land, and I am holding the possession.
That land got vested with the state.
And what has happened is during.
So your Borga goes, vesting is without any encumbrance.
No, kindly see by page, kindly consider page 89 once. 89 of the writ petition, there is a departmental communication from the PLR concerned, saying that as per the office record, it is found that no patta has been issued in such and such case number, in Mouja number, Rajnagar, and no proposal has been prepared. On the
Sir, there are patta holders, they are in obviously in possession.
On the basis of the RTA information, my lord, your lordship was pleased to give.
You are not the owner, you claim to be a Borgadar. Once the land stands vested, the vesting is without encumbrance, your Borgadar can take right of Borgadar can take its place under the
Tribunal, without considering the RTA information, said that there is a direction.
You are not, you have no right, title and interest in respect of this land for us to look into RTI or the constitution.
This was the incorrect information that has been recorded by the net tribunal.
There is no right, title and interest, sir, on vesting. It is an admittedly a vested land, right?
Page 92, your lordship's order to dispose of the original application within 6 months.
Very good.
And the tribunal said that the document has not been granted to be provided to the petitioner on the basis of the RTI information.
Thank you.
Has no
Thank you. Writ petition, affidavit in opposition filed in court be taken on record. Full stop. Next part. Writ petition is directed against an order dated December 7, 2023, passed in MA 3561 of 2022 within bracket LRTT bracket close. Full stop. Next part. By the impugned order, landed tribunal, did not find any infirmity in the order passed by the appellate authority, passed by the subdivisional officer Kakdeep, as also by the appellate authority with regard to the patta issued to the private respondents. Post up. Next paragraph. Claim of the writ petitioner is based on the grandfather of the writ petitioner being a Borgadar. Post up. Next paragraph. It is admitted at the bar that the land stood vested with the state. First up, next paragraph. Vesting, in our view, is free from all encumbrances. With first up, next paragraph. In such circumstances, right of Borgadar of the writ petitioner seized on the land vesting with the state free from all encumbrances. First up, next paragraph. Apparently, thereafter, land so vested with the state was distributed by way of patta to the private respondents. Close stop. Next paragraph. Subdivisional officer, appellate authority, as also the learned tribunal found such fact. Full stop. Next paragraph. Reliance is placed on a response given under the Right to Information Act 2005. First up, such response, however, was subsequently stated to be incorrect. Post up. Next part. Be that as it may, the first response under the Right to Information Act 2005 speaks of no patta being given. First up, again, land belongs to the state, and the state is state can distribute such land by way of a patta, in accordance with law. Next part. In such circumstances, we find no ground to interfere with the order impugned before us. Post of WPLRT 13 of 2024 is dismissed without any orders to post.
The appeal in opposition file.
Yes, we have to take.
Lordship, in this matter, I am appearing on behalf of the appellant, led by Mr. Amitabh Chaudhary. Lordship, appellants were attending the proceeding every day before the learned tribunal, Lordship. But on the last occasion, the impugned order, Lordship, we have not attended due to our mistake, Lordship, and we have missed. And this order was passed against us, Lordship. My only humble prayer, Lordship, only one prayer, Lordship, that the final chance of hearing can be given to us, Lordship.
Who are you? You are the original applicant.
No, my lord. We are the private respondent number one in the.
Well, they have challenged the order by which the matter was made CAB, not the judgment.
What is your right title and interest in respect of LR plot number 3326 and
regarding the merit on this, I will rest your lordships kindly. That is not very sufficient grounds in this matter, my lord. Well, only we have.
We can't waste a judicial time on the basis of 32 all out, with all due respect, sir.
Yes.
A writ petition is directed against an order dated July 31, 2025, 2023, or passed by the West Bengal Land Reforms Tribunal in OA 2854 of 2015, within bracket LRTT, post up. Next paragraph. By the impugned order, learned tribunal, heard after hearing the parties at length, concluded the hearing and reserved judgment. Next paragraph. Subsequent to the order dated July 31, 2023, learned tribunal, passed an order dated August 17, 2023 on merits. Next paragraph. Order dated August 17, 2023, passed by the learned tribunal, disposing of the original application being OA 2854 of 2015, within bracket LRTT bracket closed, by directing the concerned BLLRO to mutate the name of the original applicant in respect of 0.12 acres of LR plot number 3326 and 0.20 acres of LR plot number 3324, is not challenged by the appellant, by the writ petitioner. Next paragraph. It is the contention of the appellant that, although the appellant was represented on every dates of hearing before the learned tribunal, only on July 31, 2023, the appellant was unrepresented, and therefore, an opportunity of hearing should be afforded to the appellant. Essence of appellant writ petitioner. Next paragraph. Ordinarily, such a request would be considered as innocuous and readily accepted. However, in the facts of the present case, we find, the learned tribunal, reserved judgment on July 31, 2023. It was within the notice and knowledge of the writ petitioner that, the learned tribunal reserved judgment on July 31, 2023. A tribunal proceeded to pass a reasoned order on the merits of the matter on August 17, 2023. As noted above, no challenge is leveled to the order dated August 17, 2023, disposing of the original application on merits. Next paragraph. Writ petition was affirmed on July 18, 2024, limiting itself to the challenge to the order dated July 31, 2023. Next paragraph. Writ petitioner, therefore, waited at the fence from July 31, 2023 till the delivery of the delivery of the order of the learned tribunal on merits on August 17, 2023 to find out the result of the proceedings. Thereafter, it waited for another 8 months to file the writ petition only to challenge the order dated July 31, 2023. Next paragraph. That apart, we find no merits in the present writ petition warranting interference by us. WPL Act 104 of 2024 is dismissed without any orders to court. এই জন্য আমাকে এত ভয় challenges to 21st November 2024, order dated 21st November 20. Give me a second. Contempt petition was disposed of, or what was disposed of?
Application, original application was disposed of by the learned tribunal.
What was the original application about? Owner. Certainly.
We filed an application for correction of their name and the right repressive right.
That was allowed.
That was not allowed. So they came to the court. Made an application there. There are 3 days for hearing. And just some date, the verdict was page 263. There's a money. The land government is the point of thing. That another application for the practice pending, you go to another way, you go to side ground, and there is submission of facts in filing file. My submission was that submission of facts was there. Bank auction,
you are the owner through bank auction. Private respondents is claiming title through state. As what? As the owner? As how? That who's the original owner? Bank auction meaning that the property is belonging to X who mortgaged the property and bank sold it. Right?
There is a long history. The original owners, they enacted for 15 years one list. Private respondent. They enacted him as a list.
Very good. Bank auction obviously purchase fee from encumbrances, complete title to you, record of rights, you are mutated. then there is a further proceedings for cancellation of that record of rights right. Then what did the tribunal do?
Tribunal, just before, the government wanted to oppose it and to file their evidence plot. They were given the time to file the opposition. And when date of hearing, suddenly the bearer, you also can see, the government representation submits
Page?
data.
Page? Today, what is the status of the property? Private respondent's name?
They gave a status report and the bearer said, I have cancelled. Mutation in my blood and it has been, their name has been disclosed.
Who's appearing for the private respondent?
I am appearing for the private.
Without giving me notice and without.
What is the date of your title deed?
My title deed, my interest flows from 1943,
Not before Job Channa?
No.
Thankfully. 1943. What is the date of sale?
No.
What is the date of sale?
I 2019.
No.
On auction.
Free from encumbrances.
No. Lord, may I, my lord? I'll just, my lord, within 2 minutes, I'll make things clear. In 1943, my lord, the original owner of the land had inducted this private respondent, Center Glass Industries Limited, as a tenant. 1953, the West Bengal State Acquisition Act came. Now we vested the land because it was a factory, then it was sought to be vested. The original owner of the land prefers a suit saying that I am the owner of the land. The suit was decreed in his favor. The state preferred an appeal, title appeal.
Sir, how can this OA be disposed of in this manner?
No, it has not been disposed of in that manner. This entire history has to be.
So then has to be recorded that state is the owner, then that's the status report. What is that status report?
That status report has not been placed before Lordship, my lord.
What is that status report?
I'll come up with that status report. My lord, they are...
Sir, even if the status report says ROR land stands vested with the state, as you are rightly pointing out, that finding has to be returned by the tribunal. That decision on merits have to be given.
My lord, that application...
That's today there are 3 claimants to the property.
My lord,
give me a second. There are 3 claimants.
Applicant is the private respondent before the landed tribunal, not the...
Very good. Give me a second. There are 3 claimants to the property. State by virtue of vesting, purchaser through a bank auction, title flowing from the original owner by a person. 2 original applications in respect of the same land. Correct me if I'm wrong.
Only 2 applications filed by the private respondent.
Very nice. 2 applications filed by the
private
respondent. Right, very good. Now, of the 3 stakeholders, claim holders, who is correct has to be decided by the tribunal.
It was already decided by this honorable court.
Who? Wait, sure.
My lord.
My lord, me.
Now, by this honorable court, as long back as in the year 1973, that they have no right over the land, it is vested to the state.
2015 purchase, 1973 is neither here nor there.
By this honorable court.
Sir, that finding has to be returned by the tribunal also. That the claims are without any basis.
Oh, these are, my lord, if your lordship kindly appreciates the chronology of events, I'll file that status report before your lordship. I'll file that status report.
Sir, the land may have vested with you, no issues. On the basis of that vesting, you can correct your record of rights. But apart from you, there are 2 other claimants. Somebody has to conclusively pronounce on their rival claims. Both may go out of the window.
In fact, both has to go out of the window.
So say so by this has to be said so by the tribunal. If the auction purchaser claims title through a tenant, he can't have a right of ownership either way. At best a tenant.
Not even a tenant.
At best a tenant. He can't be the owner. There is another person claiming ownership. In fact, there are 2 persons claiming ownership. One is the state by virtue of an act of state, and the other is a person who is claiming ownership by devolution maybe. But between the 2 of you and the 3 of you, somebody has to decide conclusively.
It was decided conclusively by the concerned DLRO, my lord.
All these things were brought into the tribunal and tribunal should have.
It was.
Tribunal is not saying that the issue is res judicata because of this. I could have understood that also. Tribunal has to decide of the three claims who's correct. Yes, sir.
Kindly come to page and pass.
Okay, sir, this is a division bench. After that, there are certain other events occurring.
Up to the Honorable Supreme Court.
So these gentlemen, the petitioner before us claims himself to be a owner. I don't know the length and breadth of the claim. Now that somebody has to decide that he has no right, you have no right, or you have a right and the state doesn't have a right. So who's going to decide that?
Well, the state comes up with a report before the learned tribunal saying that we have
You come up with a report before me in this.
Your Lordship has always granted liberty to prefer an appeal against that. Well, the tribunal also granted liberty to prefer an appeal against that. Well, your Lordship may kindly do not, my lord, record anyone's right over the land.
State will submit a copy of the report filed before the tribunal as noted in the impugned order dated November 21, 2024. On the next date, first of next paragraph, let's direct petition on May 14, 2025. Let us see. Let us see. I'm minded to remand. If I need to decide on the title, then I'll allow you the parties to exchange affidavits. Otherwise, I'm minded to remand.
Once an important condition. Similar.
We say model
40 and 40.
আজকে 340 আছে
But this order has to be. The learned tribunal dismiss the contempt application as being tampered. But this order cannot be. Has to be remanded back to the learned tribunal.
I beg to disagree. Hey, sir, there's no pleasure in allowing his application. The only pleasure is a dismissal. Writ petition is directed against an order dated January 22, 2025, passed by the West Bengal Land Reforms and Tenancy Tribunal in MA 236/2024 in OA 696 of 2022. Post up. Next paragraph. Learned Tribunal found the contempt petition to be barred by the laws of limitation. Post up. Next paragraph. Petitioner approached the tribunal complaining of violation of the order dated March 31, 2023. Foster. Such order dated March, where is that? March 31, 2023, required the concerned block land and land reforms officer to dispose of a proceedings within a period of 4 months from the date of communication of the order to him. First up, next paragraph. Order dated March 31, 2023 was communicated to the concerned block land and land reforms officer on April 27, 2023. First up. Period of 4 months to comply with the order, therefore, commences on and from April 28, 2023. First up, next paragraph. Contempt petition was filed on
1st of July 2024.
July 1, 2024. First up, next paragraph. Therefore, taking 4 months from April 28, 2023, the concerned block land reforms officer was permitted to complete the proceedings within 4 months thereof, meaning thereby concerned block land and land reforms officer puro sentence টা কেটে দিন, so অনেক complicated হয়ে যায়. As provided for in the order dated March 31, 2023, in therefore, comma, কেটে দিন ওখানটা. Order dated March 31, 2023, therefore, comma, require the concerned block land reforms officer to complete the proceedings by August 28, 2023, taking into account the fact that, comma, the order was served, order was received by him on April 27, 2023. Full stop. Therefore, comma, the contempt petition filed within August 27, 2024 will be construed to be within the period of limitation. Full stop. In the instant case, comma, the contempt petition was filed on July 1, 2024. Full stop. Next part. In such circumstances, comma, we find that, comma, learned tribunal erred in dismissing the contempt petition on the ground of limitation. Full stop. Next paragraph. Consequently, we set aside the impugned order dated January 22, 2025, and remand MA 236 of 2024 to be heard and decided on merits. Full stop. Next paragraph. WPLRT such and such is disposed of with cost. Day before yesterday? Disposed of by day before yesterday? Come back once again before us. It's such a pleasure to look at you at least. That is why I uttered those words. The moment I uttered those words, you will take umbrage.
My lord, I am appearing for the petitioner. The order was passed behind our back without serving any notice of us. And except my lord, petitioner number 3. Then my lord.
What is the relationship between the other petitioners with the petitioner number 3?
And when notice was received after the matter was disposed of.
Petitioner number 3 also received notice after this.
Yes. Well, I tell you, Lord.
So therefore, no notice.
5th September 2024, her order was passed, and I received notice on 18th September 2024. One petition. Now, my lord.
Order impugned is 27th March 2025.
That is in ME. I filed, thereafter I made
an application for recalling.
Yes, but before that I came to High Court. High Court, my lord, granted liberty to file objection there. Then, my lord, I filed recalling application. This is the order, first in, my lord, recalling application. There are 3 points, my lord, I am taking. I purchased the land. Thereafter, my lord, it was my.
Sir, if the original application was disposed of without notice, then it's not a question of review. It's a question of recalling.
Yes.
And then they are required to be heard and decide the matter to be decided on merits. He may have a case, may not have a case.
May I submit my
lord, I am for the private respondents. I filed the original application. I
have to show us that they were served and take your seat. We'll dismiss this writ petition.
My lord, the order of the original application was that a notice, a proceeding was initiated by the BL and LRO.
But we are not wanting to know the merits. Show us that they were served with the original application.
My lord, I have served it, but they received it after the That is,
to Turkey.
and
But
my lord, in whatever, they are not affected by the order because the learned.
they are here because they are affected. How are you to decide whether they are affected
No,
or
my-
not affected?
I don't know, may I humbly submit, my lord?
Our names were recorded, my lord,
They-
on our application.
Madam, they are before court because they are affected.
My lord,
They-
I bow down, my lord, but one thing, the learned tribunal directed to complete a proceeding which was initiated by the BL and LRO after giving hearing, opportunity of hearing to all the parties, including the.
Madam, that is on the
petitioners over here.
merits. They all that they require is a hearing in the original application. They may have a case, may not have a case.
My lord.
But they are entitled to a notice. Ashun.
My lord, may I take 1 minute?
We are setting aside the order, remanding the matter to be heard on merits.
Not only that, my lord, there was an appeal preferred by them. Suppressing that, they moved.
To take those points before the OA court, not before us. You
That was not rejected.
ready?
Recording.
We'll come back after the recess and take it. क्या has been that? 2 minutes तो शेष होगा. ठीक है. ऐसे जाओ.
My lord, may I have your lordship's leave? Your lordship is disposing, has been pleased to dispose of the matter. So, my lord, may I have your lordship's leave? It won't be continued after 2 p.m., no?
We'll have to dictate the order. You want to go somewhere?
My lord,
Asansol?
no, my lord. I don't.
Shatabdi is there.
No, I don't have to go to Asansol.
Then?
My house is at Bardwan, not at Asansol.
If you want to, you can remain. If you don't want to, leave granted.
Grateful to your lordship. वो अच्छा जांच कर Hey, what is it?
পেজ করে দিচ্ছি না ট্রাইব্যুনাল অর্ডারটা। হ্যাঁ ট্রাইব্যুনাল অর্ডারটা যেটা আমরা ফাইল করেছি ওটাই থাকবে, আমাদের কিছু ফাইল করতে হবে না। যেটা আমরা অলরেডি ফাইল করেছি আবার শুনে নিই। ঠিক বলে গেছে অর্ডারটা। হ্যাঁ হ্যাঁ ট্রাইব্যুনাল তো আমাদের হারিয়ে দিয়েছিল না, সেই অর্ডারটাকে হাইকোর্ট খারিজ করে দিল দেবে। আজকে অর্ডার বেরোবে, সার্টিফাইড কপি তুলবো, ট্রাইব্যুনালে হয়তো এক সপ্তাহ পরে যাবো আর তবে ইচ্ছা যদি হয়তো ট্রাইব্যুনালে সার্টিফাইড কপিটা থাকে। অর্ডার ফাজলামি করলো বলে কি আছে।
ছিল যে আপনি আপনাদের এসপার একটা বোর্ড বেরোবেন, এই যে রিপোর্টটা তৈরি হয়েছে রিপোর্টটার কোথায় ভুল আছে পরে বলেছে যে বলোই ওটা পরিষ্কার করতে পেরেছে যে হাসপাতাল হচ্ছে ওটিএম ক্যাম্পেইন করছে, ওটা বুঝেছে। বলেছে আমাদের যে খারাপ তৈরি করেছে। হয় আছে জীবনে শুরু হ্যাঁ এটা সে করে আবার আবার এখানে আসতাম সেটা সেটা পুরো একটা অর্ডার
তারপরে আমাদেরকে তো নর্মাল চলছে এটা স্যালার করতে মেরিট করলে আমাদের আবার ওয়েটিং অবজেকশন আপনি যদি নাও ওয়ের মধ্যে ইয়ে আছে ওয়ের মধ্যে পার্টি করেছে পর্যায়ে করেছে ওয়ের পার্ট অবজেকশন ওয়েতে যখন ফাইল করবো না তখন 8% ওয়েতে
তোমরা ছিলে না
ছিলাম না বলতে হয় না
আপনি আমাকে ভালো করেছেন 16 সালে কোনো প্রশ্ন
আমরা
উড়ে গেছে অর্ডারটা কি সাইলেন্স করে আমরা সেকশন 50 করে ক্লিয়ার যে লোক সেম কল চাইতেন ছিল যে লোকটা সেটা তারা মারা পিটিশনটা তো আপনি আমরা মারা যায় এই মারা গেল তাহলে তরবারি যেতে পারবে না কষ্টে পারবে প্রথমে বাবা এই কারণে মরা লোকটা ওই লোকটাকে আবার আমার প্রশ্নটা একটা নতুন অ্যাপ্লিকেশন শোনেন না আমার আছে সেম হতে হবে Still, title, same land, same plot number, same data, same area, sufficient. That ছোট্ট না সেম পর্যবেক্ষণ হ্যাঁ how it is made that is what is mean how it is made challenge করুন challenge করুন আমি সেটা নর্মালি করব আপনি তো ঠিক বলুন এটা you are in the knowledge suppression of fact serious suppression ওখানে কত নম্বর আছে
43 8 নম্বর
মানে 43 ওখানে আছে কত ভালো করে দাও
সিআরকে ফোন করছি ফার্স্ট টাইপের অ্যাপ্লিকেশন একটা আপনার দেখতে হবে পার্টি করে পার্টি করে এই তো কম্পিউটার ইয়ে করছি আপনার করছি এটা আপনার কাছে চাইবে না যে আমার কোশ্চেন জানি কি किसी की ऑफिस से पूरे दिसो किसी की कॉपी कोई कीबोर्ड के কোথায় এই সার্ভিস এথিক্স কোথায় কোথায় যাবে প্রমাণ করতে আমি কিছু
এটা কোথায় থাকে
সে আগে ফোন করুন
হচ্ছে না
আপনি এটা খুলুন
শেয়ার করো
কেস স্ট্যাটাস শেয়ার प्राइवेट खराब केस अपनी बात पूरा যেটা আমি দেখি এটা দেখি যে অ্যাডমিটেড পজিশন নয় এটা অ্যাড্রেস টু পেটি আপনাকে কি করে এলো এটা কেমন বোঝা এটা আজকে যেটা কাজ তোমাদের ফার্স্ট ওয়াই দেখে তো ওটা ফার্স্ট ওয়াই আপনাকে দেখো আপনাকে ফার্স্ট ওয়াই কি
বলো
আপনাকে
না না বলুন
তাহলে এটা কাজ করুন এমন একটা ডকুমেন্ট আপনার হাজবেন্ড during the time of document here.
আমি থাকবো যে সময় পাই মানে আপনার ফার্স্ট রিপ্রেজেন্টেশন হবে আপনার ফার্স্ট রিপ্রেজেন্টেশন হবে এটা তুই কথা আমি জানি না এর আগে আমাকে দেখ হাজবেন্ডের করার পরে এনারা রাখবে কোথায় এটা কবে ফাইল করেছে অর্ডার কোথায় ম্যানেজ করেছেন অর্ডার পেন্ডিং আছে এখন মারা গেছে আপনি ঠিক আছে সেটা ইম্পর্টেন্ট হ্যাঁ অ্যামেন্ড করে ওকে Where is your representation? After the date. After the date. After the date of your husband, before the date of the husband. That is. Or this is where the number of signature does not have proof of the delivery. বাজারে করতে পারছি বাড়ির অ্যাড্রেস ওর সার্ভিস বুকের অ্যাড্রেসটা কি আছে আমার বাড়ির অ্যাড্রেসটা কি আপনার হাজবেন্ডের
1/4 declared. 1/4 declared. Yes. Correct. Correct. আপনার বলতে second by participants. Second by participants. না না হয়ে গেছে যেটা আছে আমাদের unless marriage how will
বলতে পারবো ওদের খাতা লেখা থাকে না তাহলে ওদেরকে বলতাম
এই অর্ডার শুনতে এসছো চলে গেছে
করেন না
আজকে আসে না প্যান সাচো হ্যাঁ অর্ডার আছে তাই তো বলছি হ্যাঁ এগুলো দেখলে আমার সাথে রেকর্ডিং করাতে হবে বাচ্চা আমি বলছি তো আজকে সাড়ে তিন কি হচ্ছে কথাটা আসবে মাইনর তুমি বসছো না ওঠার সময় বলে দিত সাড়ে তিনটে দেখবো না জুনিয়রটা কি আছে তুই আছিস ওটাতে কন্টেন্টে হ্যালো হ্যাঁ তো দেখিস না ওখানে পার্সোনাল অ্যাপিয়ারেন্স হয়ে আছে অফিসার গুলো আমার সঙ্গে দেখ এটা আমি শেষ করে দিই তারপরে অর্ডার দেখ অর্ডার আমি চেষ্টা করতে সাথে তখন মেয়ের কাছে দিয়ে বলবো আমার ফ্যাক্টরি কাছে জানা না কোনো কথা না কলেজ আজকে তো বন্ধ হস্টেলে দেখা হলে
Key batchment. The writ petition is directed against. Oh, one person has gone to Bardhaman, the other person is here. Very good. Writ petition is directed against an order dated March 27, 2025, passed in MA 1697 of 2024 in OA 2078 of 2024 within bracket LRTT. Full stop. Next bracket. Learned senior advocate appearing for the writ petitioner submits that, none of the writ petitioners received any notice of OA 2078 of 2024, excepting petitioner number 3, who received the notice subsequent to the order of disposal of OA number 2078 of 2024. First up, he submits that, Thereafter, comma, the writ petitioners approached the learned tribunal for the purpose of recalling of the order of disposal of the way 2078 of 2024, first up, such application being MA 1697 of 2024 was dismissed by the impugned order, comma, incorrectly. First up, next part. State and the private respondents are represented. First up, next part. In response to a query of the court, comma, learned advocate for the private respondent submits in a usual fairness that, comma, notice of the original application was not received by any of the petitioners excepting petitioner number 3, and that too, comma, subsequent to the disposal of the original application. Post up. Next part. In such circumstances, comma, since the petitioners were not heard by the learned tribunal, comma, prior to passing its order on merits in ways 2078 of 2024, comma, it would be appropriate that, comma, the tribunal does so. First up. Next paragraph. In such circumstances, comma, we set aside the impugned order dated March 27, 2025, passed in MA 1697 of 2024. First up, we allow MA 1697 of 2024 and direct OA 2078 of 2024 to be heard and decided on merits. First up, have you filed any objection? Next paragraph. Petitioners will file, what is it called, written objection there? Or
Affidavit in opposition.
Will file affidavit in opposition to OA 2078 2024 within 2 weeks from date? Within 2 weeks from date. First up, reply if any. Yes, sir. Reply if any within 1 week thereafter. Within 1 week thereafter. First up, next paragraph. Learned Tribunal will thereafter proceed to hear and dispose of OA 2078 of 2024 on merits. Post of next part, WPLRT 50 of 2025 is disposed of without any orders to cost. Impugned order in MA set aside, MA allowed original application affidavits, original application to be heard and disposed of on merits. Where is the origin? Consequently, consequently, comma, the order passed in the original application dated September 5, 2024 is also set aside. Okay. As subsequently corrected করে দেবে করে আমি একটা জায়গায় আমি ঢুকিয়ে দেবো। All are here. দাদা ওটা লিখে দিন তো, affidavit of service filed in court be taken on. All the respondents are represented.
44, Your Lordship. I'm appearing for the writ petitioner respondent. Lordship, the appellant is Mr. Supratim Dhar. Lordship, yesterday again an adjournment was taken. Your Lordship, they have taken time and
passed over.
Lordship.
Lordship, I am appealing with the repeats.
Who? Yes. Next. On the prayer made on behalf of the appellant, comma, list the appeal on May 5, 2025. On the prayer made on behalf of the appellant, list the appeal on May 5, 2025.
Mr. Somo Mujumdar is appearing on behalf of the writ petitioner, my lord. Let him start.
This occasion, the lordship directed both the parties to file the written notes of argument.
We have heard the matter. Acha,
After Mr.
acha, very good, very.
This is with regard to a huge parcel of land in the district of KHANNA, presently coaching Mohammed. Stack of division in the 1925 of KHANNA was leased out to one family. With regard to two models for mining of the well. After the promulgation of the Electrical State Acquisition Act in 1950, when the state sought to lease the land, the then CHATTERJEE filed an petition for this honorable court. That petition was disposed of in the year 1960 by dint of terms of settlement.
Where is the impugned order? Page 73.
In the paper, itself, in the paper.
73. Where is this representation?
That page of 2016 is that page 59. Communication.
Page
40.
Page 48 যে রিপ্রেজেন্টেশনটা আছে, can it be granted? Stated property long term lease চাইছে, এরপরে দিতে হবে if at all, তো পাবলিক কে অফার করতে হবে। হ্যাঁ, আর্টিকেল 16 এ তো সবাইকে দিতে হবে। Yes sir, who's for the writ petitioner? Under what provision of law can you get an individual allotment of a lease, even assuming that that lease is permissible to be granted?
Not so far as
without following Article 16?
No. Not the refer to a land policy. That's one.
Forget lands policy. What about the Constitution? Article 16, everybody has to be offered. No. You can't get it on your own.
But persons in possession can be allotted.
Gonta.
No, please see. Please come. No, they had complied with this order previously.
Wrongly. No negative equality.
No, it's not in my case, in this case.
But no negative equality.
No, may I just show to your lordship 3 documents then?
Yes.
Please come to page 57 of the paper. It starts from 55A. It's better not I place the entire document.
Yes, 55A, and what else?
In pursuance of letter number so and so, LRO, Part 1, in reference to letter number so and so, dated 13th March 2016 of AL and LR Department, this proposal for long-term settlement is taken up in respect of plot number so and so. Please come to skip over the first 3 paragraphs, paragraph 4. A lease deed was executed by the then Maharaja Vijay Chandra Mahatab in favor of Sri so and so, offering the whole Mauja for
so ultimately in 2016, what they do they decide?
Yes, please come to page 56 now. observations. By creating sublease, the successors in interest of the Chattopadhyayas have lost their right, title and possession over the sublease portion of the applicant. Sri Chai, as there was no provision either in lease deed of 1920.
Therefore, the government has enough scope to settle the land on long-term basis who opted the sublease from the Chattopadhyay. Oh, Baba, jomidari dichchen.
We are these persons.
Is this gentleman the zamindar of that property?
No, no, please.
Even if it is his decision, it is personal property.
So please come to page 59. Now, please come to page 59 now. In reference above, in connection with the petition submitted by so and so, the matter has been inquired in field and the land schedule as mentioned below of so and so acres out of more than so and so acres is found fit for distribution on LT settlement to the applicant's field inquiry report enclosed.
Very good. Anything else?
Sketch map of the plot are enclosed. The plots were given on so and so for 919 years by the Maharaja during the pre-independence period solely for mining purpose.
Very good.
Not a
Anything
mining
else?
purpose.
Very
Law does
good.
not stand in the way for any longer. It's not being utilized for mining purpose. It's 3 cutters of land for residential purpose.
Anything else?
In gross violation of the terms of the lease, transferred some portion of the leasehold property with a registered number so and so to one Siddhartha Kunar for real estate business. Sri Siddhartha Kumar then became the proprietor of so and so developers, project some so. In view of the violation of the lease agreement done by the legal heirs of so and so, the government is now at liberty to treat that lease as a nullity and resume the land, and take opinion may, however, be taken in this regard. Now, in accordance therewith, a model is prepared. The next page. 16 is not very happily legible, but
Page 60?
60 is a
60.
It's no dot. Please take the original page 60. A model order sheet has been prepared by for the LTS purpose, which is enclosed for vetting and approval.
Very nice.
A Khatian bearing number so and so prepared in the KB stage is found, which shows that the owner of the land is Forest Department, but in accordance with the order number so and so in CR, that was arising out of a settlement which resulted in an order being passed by the court. Only 50 acres of land has been transferred to the Forest Department. Therefore, recording of the whole area in favor of the Forest Department is erroneous. Valuation and sale data have been obtained from the ADSR Durgapur, from which it transpires that the average of sale data of 16 rupees so and so per acres, whereas
anything else?
Today, even in appeal before your lordship, the sole ground taken is the policy of 2012. Let them.
Very good. Tell us. We answer our query with regard to Article 16.
Not 16 may not apply. Not 16.
Doesn't apply. Wait.
Not 16 applies only in respect of not.
Very good. It doesn't apply. Doesn't apply. Yes. It doesn't matter. Appeal is directed against
not only one subject. There is a list of dates, not with the points which they have argued or raised in the appeal, not with the answers that I proposed to.
Very. Appeal is directed against an order dated March 9, 2022, passed in WPA 19922 of 2021. First up, next paragraph. By the impugned order, learned single judge, directed the state respondents to consider the proposal made by the writ petitioner in the writing dated January 31, 2016, and finalize such proposal in favor of the writ petitioner within 2 months from date of communication of the order. Post up. Next paragraph. Appellant is the state of West Bengal. Full stop. Next paragraph. Writ petitioner approached the writ court by way of WPA 19922 of 2021, seeking the following reliefs. Set out prayers of the writ petition at pages 16 and 17. Next paragraph. The representation dated dated January 31, 2012, of the writ petitioner, 6, long-term settlement of a piece of land measuring about 3 katas in favor of the writ petitioner. Full stop. Next paragraph. Learned senior advocate appearing for the appellant submits that by reason of the land policy of the state, no individual allotment of land or lease, grant of lease of any property can be made without public auction. Full stop. He refers to the land policy of the state enshrined in a document of 2012. Full stop. Next part. Then senior advocate appearing for the writ petitioner relies upon a list of dates and submits that his client initially was the lessee. First of such lease expired. First of there is no impediment in the state granting the lease as prayed for. First of in support of such contention, he draws the attention of the court to certain decisions taken by the state authorities. First of. Next paragraph. Senior advocate appearing for the appellant submits that, the so-called decision are department communication and it is not binding on the state. First of, in fact, no decision was taken for the allotment or grant of lease in favor of the petitioner, writ petitioner. First of. Next paragraph. As noted above, the writ petitioner seeks the grant of lease in respect of 3 plots of land. 3 katas of land. First up, there subsists a land policy of the state of West Bengal with regard to grant of lease of government properties to individuals. First up, such land policy speaks of public auction being held.
We have tried to distinguish this. Kindly grant me 2 minutes time.
We take note of the provisions of Article 16 of the Constitution of India. First up, in the facts and circumstances of the present case, it is established that the writ petitioner seeks grant of a largesse of the state. First up, in the present case, long time lease of an immovable property. First up, next paragraph. Individual request for grant of long-term lease, or its consideration and allotment, are in the face of Article 16 of the Constitution of India. First up, next paragraph. The prayer for grant of long-term lease as contained in the representation dated January 31, 2012, is contrary. 2016 is contrary to the provisions of Article 16 of the Constitution of India, which requires the state to undertake distribution of land, by public auction. Full stop. Next paragraph. In such circumstances, neither the writ petitioner is entitled to such a favor, nor are the respondent authorities are with the requisite jurisdiction to decide on such a request. First up, learned trial judge erred in directing the respondent number 2 in the writ petition to consider such proposal and to finalize it. First up, next paragraph. In such circumstances, impugned order dated such and such is set aside. First up, MAT such and such is disposed. FMA such and such is along with all connected applications are disposed of without any order as to cost.
No, there was a list of dates with notes. Those
are for the superior forum.
No, kept with the record. Your lordship directed to file this.
Very good, thank you so much.
Let it be kept with the record.
Yes, it is kept with the record.
Written notes of argument may be kept.
Everything kept with the record. The advocate's memo. Advocate's memo also is kept with the record.
Your lordship directed. That is why we prepared.
Correct. We have taken it on record. Anything else we can
let it be on in the order sheet. That is why.
Very good. We'll write it down.
Written notes of argument may be.
We will write it down. What else can we do for you? So put it up.
Mr. Satyajit Talukdar appearing on behalf of KMD, his mother has expired today, Lordship. And
not today?
Not today, my lord. 2 weeks. After 18th, my lord, any
on the prayer made on behalf of the appellant. List the appeal in the monthly list of June 2025.
Malad, take it on May, Malad.
Why?
Malad, a long time, Malad, this time later.
I am appearing for the appellant, my lord. I'm praying for not today, my lord, because Mr. Chatterjee has not come to court, my lord, due to personal reasons.
Kindly make it twisted, my lord. I am appearing with the response.
Mr. Honorable
On the prayer made on behalf of the appellant, list the appeal on May 6, 2025.
Deep. Can it be fixed on Wednesday, my lord? Mr. Mukherjee allowed.
Quite it up.
19 কোনো ব্যাপার না, ঠিক পৌঁছে যাবে ম্যাটার।
Also, I am for the writ petitioner.
Appearing on virtually, my lord.
Lordship, in this matter,
Also, may I file?
will appear, but he expresses view to appear before. Kindly fix the matter in any non-circuit day, Lordship.
He is in circuit bench. That is the problem. He intends to do the matter.
Who's appearing?
Mr. Joyjit Chaudhary is he is now in circuit bench at Jalpaiguri.
So
intends to appear physically before your lordship. Can you fix that?
They open and non-circuit.
Lordship.
Very. Yes, sir.
Lordship, today I have filed the evidence in opposition. They have, Lordship, filed this appeal after getting the notice of contempt. Now, Lordship, first initially moved the writ petition, that is page 29 of the stay application.
Where is the impugned order?
Lordship, the impugned order at
Can do it for the application for stay. And your order is at page
6th March 2024, page 29 of the
page
stay.
29. 21.
What is the concept of a patta? Mane title is conferred? No. Or permissive user is given?
Lordship, only this is the almost lease.
So ownership remains with the state. So here in this case, what is being done? What is the
kindly
problem?
come page 30. The author, this is the observation of the Honorable Single Judge. That
What was the
authority
writ
has
petition
agreed.
about? What is the writ petition about?
Writ petition, Lordship, my land has been acquired by the border security force for construction of their building. Now, Lordship, according to the border security force, they have total compensation amount has been credited to the state government. I filed an application for compensation of this amount. Now, Lordship, initially I filed a writ petition. Writ petition was consideration
As a
order was
patta
passed.
holder, you are not the owner.
As a patta holder, I am not the owner. Yes.
So under what provision of law are you entitled to compensation? At best, you will get compensation for the
Under
structure
section
standing.
49(1)(a), the patta land cannot be transferred.
But can be acquired?
They didn't acquire. They all on a sudden they started construction.
It is the state's land. State today can hand over its own land to another Article 12 authority, which it has done.
Now, so this has not been in compliance of law.
Show us what is the non-compliance, and more importantly, show us that you are entitled to compensation.
Also, kindly come page 30. This is the authority has agreed. Page 30 of the stay application, impugned order page and inner page 2. This
This is an observation of the honorable.
Authority has agreed to compensate by
Yes.
paying cash compensation. Where is this agreement?
This is the observation of the honorable single judge.
Maybe.
This state
Where
of
is
the-
this agreement? Which document prompts the learned judge to?
And lots of kindly come. The order impugned dated 6 June.
Where is this agreement? In writing shows that agreement. Learned judge যা লিখলেই হবে?
No, Lordship, if this is the observation of the honorable single judge, the state
Good.
before
These
the
observations may be perverse also. Please show us the document in support of the observations made by the learned single judge.
And Lordship, what is the Lordship the defense of the state as on today for the grounds of the state?
Show us your right
Alternative
to
land
receive compensation. Please show us your right to receive compensation as a patta holder. Take your seat.
Yes.
We'll give you the compensation.
Kindly come. Since the suit land is a patta land, transfer of same is barred under section 49(1)(a) of the West Bengal Land Reforms Act 1955 and cannot be purchased by direct purchase mode.
Sir, what is your right to receive compensation? My English is extremely poor. Somebody else is the owner.
Yes,
that owner has dealt with that property illegally, wrongly. What is your right
Because
to
of due
receive that?
process of law, I got the patta in respect of the land. And Lordship, this land is not transferable in terms of section 49(1)(a).
It shows 49(1)(a). 49(1)(a) of the
West Bengal Land Reforms Act.
দেখি একটা এই এখানেই আছে অল ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্ট দেখি
My lord, I have joined here, my lord.
ওটাকে অফ করুন এটাকে
You lords will mute me.
পাট্টা অ্যানেক্স করেন করা যাবে পাট্টাটা পাঠ করতে
এখানে হবে এইদিকে দেখুন আছে ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্ট আছে হতেই পারে না এই দুদিন আগে দেখিয়েছি তলার বইটা দেখি লাস্টের বইটা ল্যান্ড অ্যাকুইজিশন ল্যান্ড রিফর্মস নেই আমাদের সব আনিয়ে দাও 49(1)(a) আচ্ছা অ্যাকুইজিশনে ওয়েস্ট করে গেছে ওয়েস্টেড প্রপার্টি পাট্টা দিয়েছে এবার এই ল্যান্ডটাকে অন্য কাউকে দিয়েছে পাট্টা হোল্ডারের কম্পেনসেশন পাওয়ার অধিকার আছে এটা তো আমার মাথায় ঢুকছে হ্যাঁ গিভ ইট 49(1) আমার তো সেটা মাথায় ঢুকছে না কোনো দিক ও কি কম্পেনসেশন পাবে ও বেস্ট কম্পেনসেশন পাবে ফর দি স্ট্রাকচার 49(a) is a penalty for unauthorized occupation. 49(1)(a). No person with whom the land is or has been settled under subsequent shall be entitled to transfer. That's an embargo on you. It's an embargo on you, not on the owner.
Now, Lordship, this land which has been patta has been issued. This land has been without any due process of law. All on a sudden, the construction has been made on the said vested land.
Sorry, again my English is poor. State is the owner. You are the patta holder. Section 49(1)(a) restrains you from transferring the land without the state's consent. 49(1)(a) does not restrain the state from giving its property to somebody else, which it has done. And who are you to question his transfer? He is the owner superior to you. Who are you to question his transfer?
But then the patta has to be cancelled.
No.
Yes, that is the procedure.
Sir, let me put it this way. I am an owner of a property over which somebody else is a tenant. Does it mean that I cannot sell my land with the tenancy?
Unless this patta is cancelled.
Arey bojo,
Yes, this is the law. Lots of kindly come, page 53.
I cannot sell my property which is occupied by a tenant
This
without removing the tenant.
Now, I am not a unauthorized occupier, and my right.
My tenant is also not an unauthorized occupier. So, where there is a tenancy in respect of a land, the landlord cannot transfer that land without first removing the tenant.
Without cancelling the fatta. That is the law, Lordship. Unless this fatta which has been
Which
issued
side
due
of Bay
process
of Bengal does this law apply? Which side of Bay of Bengal does this side?
This is as per the West Bengal Land Reforms Act. Lordship, subject to your Lordship's correction. Lordship, this is the patta has been issued in due process of law. I am enjoying the land. Patta has not been cancelled. All on a sudden, Lordship, they have Lordship the
tell the Chief Justice to remove me from this determination. I can't take it. Oof. Sir, you are inferior to that state. How can you restrain an activity
Lordship,
of this state?
This is my submission, Lordship, that this is the patta has been issued as a due process of law in terms of the compliance of section 49. Lordship, patta is a valid patta.
Under what provisions of the West Bengal Land Reforms Act are you entitled to compensation? Under what provision of law are you entitled?
They have directly purchased the Lordship. This is the order of the Honorable Single Judge.
That order of the single judge is under challenge before us.
Now, Lordship, when they have, Lordship, already acquired the land without due process of law, this petitioner, this respondent petitioner has to be compensated. This is my submission.
Well,
and Lordship, my submission.
No provision of law is cited for compensation.
The provision of law, Lordship, is when this land, Lordship, they have, according to them, they have direct purchase. Now, Lordship, when
who has direct purchase? Who has purchased it directly?
According to the state. State has preferred an appeal. Well, Lordship, what is the grounds of the preferred an appeal? Kindly come to the stay application. According to the state, that they have issued alternate land.
That's a very simple case. State says it's my land.
No, Lordship, state is not said that in preferring the appeal. State, according to the state, I have given an alternative land.
That
this
should
is
also
the
be
grounds
cancelled.
of the appeal. I have preferred an alternative land, so you have a right to this property, which is a patta land. So you have a right of compensation.
When state says that they have given you an alternative land, they are acting benevolently. They are saying that we are not throwing you from that land. Since this land is required for something else, please move out from this land. We are giving you an alternative accommodation. Go stay there.
Now,
that is all that they are saying.
Let me join issue in this regard. Lordship, this observation of the concerned state that we have been given, this petitioner has been given alternate land. This is absolutely false and totally, Lordship, contrary to the records.
Right.
Till date, no land, no, Lordship, the settlement has been given to the petitioner.
They are not obliged to give you any land.
If the state is said, this is not the grounds of appeal. Only grounds of appeal, state has not said that this is my land. I have a right to transfer the same whoever, Lordship, except this patta holder. Now, Lordship, according to me, the patta is still, Lordship, existing. There is no cancellation of patta. Without due process of law, Lordship, the land of the petitioner has been utilized, Lordship, by constructing at the instance of the state. Now, Lordship, so far the Lordship alternate land is concerned, Lordship, kindly consider my opposition. That my opposition is, kindly consider my opposition. That neither till date.
Your opposition?
My opposition I have filed.
Opposition কোথায়?
I have filed an opposition. দুটো opposition file করেছি।
একটা তো অ্যাফিডেভিট সার্ভিস। আপনি কি দেখে কি দিচ্ছেন? এটা তো অ্যাফিডেভিট সার্ভিস। অপোজিশনটা কোথায়?
এই অপোজিশন দিলাম যে ফাইলে ঢোকানো আছে, দেখুন ফাইলে ঢোকানো।
না, এটার মধ্যে নেই।
স্টেট পাট্টা দিয়েছে, পাট্টা দিলে কি ওনার হলো? এবার স্টেট
আরে এখানটা ঢোকালেন নয়, দেখুন তো
দিয়েছে, তো এর কম্পেনসেশনটা পাবে কোন আইনে?
ওই যে এটা কি
জজ হতে তো মুশকিল, পাট্টা হোল্ডারকে স্ল্যাশ ওনার করে দিয়েছে, স্টেটাসটা তো বোঝ, ওনার তো নয়। ওনার হলে ডাইরেক্ট পারচেস করতে হবে, দ্যাটস দি পলিসি অফ দি স্টেট গভর্নমেন্ট, কিন্তু ওনারই তো নয়। আর ল্যান্ডটা তো স্টেটের, কে কিনবে?
ক্যান টু নয়, ক্যান না, ম্যান্ডামাস অ্যাপিলের স্টে
Hey, state, where's the certified copy of the appeal? Where's the certified copy of the order impugned?
Yes, ma'am. Certified memo of appeal you have annexed, my lord. In memo of appeal.
Certified copy is not annexed to the memo of appeal.
No, my lord. We have, my lord, we have filed this after obtaining leave, my lord.
Yes, then where's the certified copy? You have to file that certified copy also.
Worship, kindly come paragraph 6 onwards.
Apply করলে হবে না,
Where's the certified copy?
It is lying in another file.
At present, not with me, my lord. But we have obtained the birth certificate copy.
Then after you file it, there's a question of limitation also. লিভ নিয়ে চলে গেল, কোনো দায়িত্ব নেই কারো। Thereafter you have to discharge your obligation in filing it. Not today.
So let the opposition be kept with it.
You're filing it today?
Yes.
Reply also. File it. থাক এখানে থাক, লিস্টে থাক, এতে থাক।
পেজিনেশন করেননি বলুন তো, বাইরে চলুন,
দেখে দিন ওখানে।
স্টেটে পেজিনেশন কে করবে?
স্টেট করেন, স্টেট
পেজিনেশন করেন না কেন? বইটা লাগবে,
মুশকিল, এইরকম বেলোভেনেন্ট হলে তো মুশকিল। আর প্রপার্টি পাট্টা হোল্ডারের অধিকারটা কি আছে? পারমিসিভ ইউজার। What it up?
Manat, I am praying for not today, Manat.
Why?
Malay 52, there is a direction upon the state to file opposition. It is ready, we do affirm tomorrow.
Not today.
Great. Instead of not today, I'll take up
Not
next week.
today.
Agilos.
Before I open up my case, Millard, if my lord kindly permit, Millard, Patta Millard is a settlement of rent dealt with Millard by the West Bengal Land Reforms rules. Read with Millard section 42. Not Millard a license or Millard a lease. It's Millard settlement of rent. Millard, yesterday Millard, my lords were of the view that Millard I have waived my.
What is the legal position of a patta holder? Owner?
Yes, Millard, it is settled. A new Khotiyan number is opened, Millard, in the name of the patta holder. Millard, there are different kinds of patta. Millard, it depends on the nature of the patta. Millard, if the patta is a permanent settlement, Millard, we colloquially use Millard Mouroshi patta, Mokoradi patta. Millard, that's Millard the patta. Millard, it's a settlement of land by the government, and he becomes a riot under Millard the West Bengal Land Reforms rules. If he becomes riot, subject to correction, then he becomes Millard entitled to compensation. If he Millard takes the character of a riot, then
Otherwise permissive user.
It depends on the nature of the patta.
A permanent settlement or not, we'll have to look into the deed of patta.
Yes, Millard.
Patta deed.
Yes. Milord, kindly take Milord section 49, rule 32, so far as Milord my recollection goes, there is a form given Milord in the rules Milord immediately after rule 32. My lords were of the view that Milord section 8, Milord, I was wrong yesterday. Kindly Milord have a look at Milord 2013 Act once more. Milord, I should have indicated this. Milord, it was my failure that Milord I could not Milord be clear to your lordships. Kindly Milord have a look at section 80 once more. Milord, the day when Milord revisional application was Milord an order was passed, revisional application was disposed of. Milord, my right to claim this Milord was yet to Milord mature. Kindly just have a look at the language of Milord section 80. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time, this is important, from the time of the taking possession until it shall have been paid, have been so paid or deposited. So, Milord, the day on which, Milord, the payment is made, if, Milord, that is not paid with, Milord, section 80 interest, Milord, my right to claim arises. Provided.
When was the payment made?
After, Milord, the order of the revisional application. Milord, that's admitted position of fact. Milord, kindly just have a look at, Milord, they filed a, my learned friend, Milord, filed a report at page 85. Page 91 says that Milord, payment was made after Milord, the order in the revisional application. Page 85, the report starts. So, Milord, the right was yet to Milord mature. And so, Milord, there could not have been Milord any question of Milord waiving the right. 85, Milord, the report starts. Page 91, kindly come, Milord, kindly see there stand. Clause J. After the said order dated passed in the revisional application, Milord, the payment was made. And once page, Milord, 85, the report of the Metro Railway starts.
Actual payment was?
After, Milord, the revisional order. Previously, Milord, a part payment of the principal amount of compensation was made. Full payment was made after the revisional order. And the Milord, provision says, if it is not paid,
amount of compensation initially disputed, right up to appellate authority revisional code 52 lakhs in order. After getting the deposit, then section 80 kicks. So it's a fresh cause of action, not comfortability revision. Award of interest, but award of cannot. It did not, and in fact, it cannot provide for that interest component because that incident has not happened. Incidents to the interest has not happened. Incident of interest is not paid or deposited on or before taking possession of the land. Collector should. Sir. Okay, when give us the dates. When was possession taken?
Yes. Milord, possession was taken, Milord, on 10th of May 2016. They say 27th May, Milord, May 2016.
May 2016 possession taken.
Yes.
Revisional court's order is dated?
Milord, that is Milord 4th February 2020.
Come back to section 8.
Yes, Milord.
Interest component is the failure to pay compensation amount before taking possession.
Yes.
Till
actual pay.
In this case, possession was taken in 2017.
Right. 16,
whatever. Award passed.
Yes.
After taking possession.
Yes.
Appellate authority.
Yes.
After taking possession.
Yes.
Interest component not awarded either in the award or at the appellate authority stage.
Yes.
Revisional court in its wisdom directs payment of 52 lakhs and odd.
That's Milord on solatium, not on interest. Revision court says Milord solatium was not properly calculated.
In its wisdom directs 52 lakhs and odd payment.
Under a different
Head altogether. Interest component or the incident of interest has happened because possession was taken much earlier than
this quantification could not have been done unless Milord the date of payment Milord could have Milord crystallized.
So therefore the
entitlement had arisen. But Milord, what would be my entitlement? Milord, that I was yet Milord to ascertain. Milord, that ascertain
commencement date was there available. Terminus was not available.
Yes.
Once the commencement date was available,
yes,
before the terminus and judicial order intervened.
Saying that I'm not looking into section 80 part of it. Yes, yes. Yes, Milord, absolutely so. Milord, my Lord will punish me, Milord, if I am wrong. Milord, kindly have a look at page 109, 110.
I've opened it.
Kindly take Milord 110, last paragraph, last sentence. Milord, I submit it.
That 80 is available.
Yes, I am entitled to section 80 interest. My Lord will kindly keep in mind that Milord, this was a revisional application by Metro. Milord, when this submission was made, kindly see Milord the observation Milord that fell from Milord his lordship. Since the said issue regarding entitlement of interest was not raised, Milord, this is incorrect because Milord, I raised this before competent authority. I raised this Milord in the previous matter. My Lord was Milord observing that Milord, the Honorable Single Judge Milord erred in Milord making this observation because this observation is not what is borne out of record. Record says something else and record will speak for itself. So Milord, Honorable Single Judge opined that Milord, this section 80 was not raised by me either before competent authority or before appellate authority. I raised it before everyone. The same, that is why the same cannot be made subject matter of adjudication, in the instant application at the instance of the opposite party who has accepted the judgment impugned. Milord, why this? Because Milord, the revisional application is not by me. Because Milord, section 80 Milord is not claimed anywhere, which is Milord not inconsistent, Milord, in consonance with what would transfer from the records. The claim petition is here, appeal my Lords have seen Milord yesterday. Everywhere Milord I said, give me section 80, though Milord I was under no obligation to ask for this. It was Milord going by section 80, Milord obligation of the authority to pay me along with section 80 interest. The day they Milord ultimately pays the principal amount of compensation. If that is not paid, Milord, this was Milord, really Milord, an over-ambitious claim of section 80 in my claim, because I ought not to have claimed that then. Milord, unless it is paid as per section 80, Milord, my cause of action arises. And Milord, waiver, Milord, I have a second limb of submission also. That was a premature claim.
He raised it, actually raised it. Not at all.
At a premature stage, I'm sorry.
You had raised it at the appellate.
At a premature stage, when Milord going by section 80, it was not for me, Milord, to raise. I ought to have waited, Milord, till Milord the money comes. And because of this, Milord, at page 112, Honorable Single Judge also gave me liberty.
You did not wait for claim of interest under section 80 till the money comes.
Yes.
You could have claimed it by saying that possession was taken without payment of compensation. Therefore, section 80 has kicked in. So whatever compensation you give me, add 9% to it till the date of actual payment.
Milord, again, Milord, I'm sorry, Milord, I'm reiterating. Milord, that was not for me to say going by section 80. That was for the authority, Milord, to give it without any claim being made. If that is not paid, then Milord, the cause of action actually arises.
So award did not speak of 9% interest. You preferred an appeal claiming 9%.
Because Milord, that was something to be granted in the award. Section 80 is not something which is to be granted in the award.
Issue was raised.
And now, Milord, so far as waiver is concerned, my lords were of the view that Milord, I have waived my right. Because I have claimed it, Milord, firstly, waiver does not arise. Secondly, Milord, yesterday, Milord, my submission to your lordship was that, Milord, yes, I can waive statutory right also. But, Milord, there is an exception carved out to that. Milord, if the benefit is, Milord, for the public benefit, if the provision deals with, Milord, a public benefit, then, Milord, anything given, Milord, under the statute, Milord, cannot be waived, Milord, by any, Milord, citizen of India. That is what, Milord, has repeatedly been said even by full bench of, Milord, the Honorable Supreme. I can waive contractual.
36 Article 136 হচ্ছে Landed charge বলছে barred because of the revisional court's order. Claim is barred today. Is it a plausible view? Claimed not allowed. Not allowed. Claim to have been. কথা হচ্ছে plausible view হয়ে যাচ্ছে আমরা করে we may have personally may take a different view কিন্তু এটা আমরা কি করে করতে
Let us, Milord, I'm sorry. Let us, Milord, assume a situation.
Give us a second. There are two orders before us. High Court's order. One is a revisional court's order and the order under appeal. Revisional court order at page 111, first paragraph, is incorrect to an extent when it records that no claim was made before the appellate authority.
And also to the extent that I have accepted the award.
You did raise this issue before the appellate authority.
Yes. Not given. Not, Milord, given.
Once you have raised that issue and the court is silent on that issue, let's take it as silent on that issue.
Denial. Refusal.
Then will it be visited by res judicata? Number one. Number two. We may be sympathetic to your client and may take a different view than as recorded by the impugned order. But our hands are also tied because your hands got tied because of page 110, 111.
111, Milord, gives me a liberty.
Does not.
In Milord,
Does
that
not.
becomes OTOs.
That's what the learned judge says.
The learned judge, Milord, gives us a liberty, Milord, knowing that, Milord, this liberty is, Milord, meaningless.
And you accepted it and danced around with it.
Milord,
your choice.
Honorable Court, Milord, gives me a liberty
to your choice.
Claim somewhere.
So we can also.
That liberty means nothing.
We can also write in our order, sun rises in the west, and you're happy with it. We are also happy with it. It doesn't mean anything.
That, Milord, sun rises in the west was written in, Milord, 110, not in 111. Milord, let us, Milord, assume, Milord, a situation. Milord, I'm sorry, Milord, I'm, Milord, troubling your lordships. Let us, Milord, assume a situation where, Milord, I do not raise a section 80 claim. Milord, I will answer, Milord, the res judicata issue. I do not raise a section 80 claim. Milord, before, Milord, I competent
Order to rule 2.
Before appellate, yes.
Order to rule 2, gone.
Milord, section 80 says, Milord, I wait till, Milord, the money comes. If, Milord, the money...
Your reasoning is a plausible view. No issues.
Milord, that is the...
But your reasoning, we are not in a position to accept because of the revisional court's order coupled with the trial court's order. Now, the trial court's view is a plausible view. We just cannot shuck away from it.
But kindly see the trial court's view once. It says, Milord, res judicata. Why? Because revisional court did not grant you that.
Correct.
While saying so, Milord, the revisional court's liberty given, Milord, that was not at all taken into account, Milord, by the writ court. Milord, I know when I ask for something, I don't get it, Milord, that applies, Milord, as res judicata. But, Milord, if I apply for something which, Milord, time had not yet come to apply for, does not apply as res judicata. My lord, this claim made by me before the competent authority was not in tune with section 80. My lord, it was, my lord, my mistake that I raised the claim. My lord, that cannot apply as res judicata. My lord, the claim matured when the principal money came, not before that. My lord, if I was entitled,
রিভিশনের সময় যাওয়া উচিত ছিল, রিভিশনাল কোর্টকে গিয়ে বলা উচিত ছিল।
my lord, my statutory right cannot get vanished in this way. My lord, so far as waiver is concerned, my lord, may I rely on 3 decisions? Then, my lord, I will deal with, my lord, this res judicata part of it. Or if my lord wants us, my lord, to come back on any other day, my lord, I am amenable to that also.
না ওয়েভার তো নয়, কিন্তু
My lord, waiver goes. My lord, tomorrow, yesterday, my lord, you were facing, my lord, the hurdle of waiver.
Keep that judgment, we do not know. We'll have to think aloud. We are thinking aloud.
Yes, my lord.
But even if we are not on waiver, then also.
Now, res judicata because of refusal, my lord, to grant something which I, my lord, mistakenly prayed for.
And the authority had the jurisdiction to grant you that relief. Section 80 application will be before the same authority.
No application is contemplated under section 80, my lord. It's like, can you
So it should have given it so
automatic? It's automatic. It's automatic. My lord, in case that is not given while paying the principal amount,
even
then
worse,
my lord,
automatic যদি হয় and not granted by the High Court, then it's even worse.
For the authority.
my lord, I draw an analogy. My lord, I asked for something before your lordship today, which I am not entitled to as on date. My lord does not discuss, my lord, what I have asked for, but does not grant it either.
In a writ petition, you ask for divorce, and we are silent on that issue. Amongst other things,
Does
you
not
also
apply as res judicata.
ask for divorce, right? And we are silent on the issue of divorce, and we proceed to modulate the rights of the parties in the other aspect.
Right.
Because we are wholly without jurisdiction with regard to divorce, therefore no res judicata.
Right.
Here is a case, authority, appellate authority, both have.
I'm not on jurisdiction. My lord, suppose, my lord, my lord, got engaged with a lady. My lord asks for divorce without, my lord, the marriage being there before the learned district judge. I do not get it. Then, my lord, marriage takes place. My lord, cause of action arises. I ask for divorce. I mean, it's like, my lord, I applied for, my lord, the interest at a point of time when, my lord, the right to have the interest, though accrued, was not crystallized.
Your right accrued and crystallized. Terminus was yet to be determined because of the
Yes, my lord, I stand corrected. Crystallized, but my lord, quantification, time to quantify had not come yet.
Quantification could not be done because of the terminus not still available. So there, your right was there, it was crystallized, absolutely. And the learned judge, whatever in your presence happened is 52 lakhs or not. That is why the learned judge got embarrassed and said, I can't touch my earlier order.
That was a coincidence that my lord.
Maybe.
Does the aggregate of the aforesaid amount comes to 251?
Read court order is purely
with 9% interest in terms of section 80. That could have been
given. Aram se diye dite hobe. Not given. Aram se diye dite hobe.
Roshidi is, my lord, all the more against us. My lord, I can follow that.
My lord, the facts,
come back on a
facts are different, my lord. The facts which are mentioned, my lord.
He seeks to assist you. You gracefully accept his
absolutely, my lord. That, my lord, helps us a lot, my lord, to address.
Always. No doubt about it.
We will come back on a better day. So, my lord, waiver I need not address here.
No, we have not said anything of whether you need not or you need to. Your choice. Not today.
Tomorrow I am not available, my lord.
But ask your junior to remind us if we come to that matter.
Great.
Grant you time.
Lord, make it part of my lord.
Joint prayer, my lord. I also joined it. My lord, my learned friend in that.
Chal, pore it up.
Grateful.
Of the appellate.
Your Lordship, yesterday, Your Lordship told me that the judgment of 2020 SCC, I have gone through, but not thoroughly. But I have gone through that, not thoroughly. This is the judgment.
I, sir, with all due respect, I have not understood it also. So therefore,
Lord, I have gone through this judgment, but not thoroughly.
so you want time.
I want the time. Well, one point I am, well, one point is, may I be ranged, Lord, that clause 363.3, Your Lordship has said 363.4. I am pointing out 363.3. The 363.3 said that if there is no compensation or position, that is totally silent.
If I have understood that correctly, under the old Act, LA Act, if possession taken, compensation not paid. Possession means vesting, therefore, Right to Fair Compensation Act will not apply. Possession taken, vesting, and compensation paid for interest also, no Right to Fair Compensation Act. Where possession and compensation both not,
yes,
then only Fair Compensation Act. In your case, in the case that, yes.
In my case, no position, no compensation.
Vesting happened because of those notifications. Possession were taken. Possession was taken.
Possession has not been taken. Let my line friend show the possession has been taken. The possession and possession certificate has been handed over to the recurring body. Let my line friend show. I raised this question before the honorable trial bench also. They bypassed that point.
Yes, sir. When was possession taken?
No, my lord.
Notice under section 6 and section 4. When was it published?
My lord. If I am not wrong, my lord, his brother, my lord, petitioner, brother filed a case, my lord, 89, before the honorable court. My lord, this, my lord, details order was there, my lord. They, my lord, handed over, they took money, his brother, my lord, took money, and my lord, they received the notice. My lord, kindly have a look this paper books.
Very well. Not today. You will go through the judgment. Come back. Yes. Not today.
All right. Kindly give me 15 days time. Another point is this, Lord.
In 15 days time, the determination will change.
No.
Then not today.
Let the matter be parted before lordship. I have.
Till date, I have not done a parted. So all are hard and judgment delivered. No part, no hard.
Then the matter will be fixed on
tomorrow. Not today.
Only not today.
Yes, sir. You read the judgment.
Let us put the appellate. This is an appeal challenging an order of conviction and sentence for life. For life.
How many prosecution witnesses?
150.
15.
15.
302.
Right.
Any eyewitness? Circumstantial. Last seen together.
Last seen together, and one, my lord.
You kidnapped the victim.
That was the allegation.
Parents of the victim came to the box. Parents of the victim came to the box to depose.
Right. The person who saw them last together, that person.
Who's that? PW?
That is PW 6.
Give us a second.
Page 25 and 26. He is also interested.
My lord, the name of the petitioner has been transferred by the full Mandi PW6 and also in our 164 statement.
And the PW6 deposed that she saw them last together. She also deposed as well as the father and mother of the deceased victim.
Why do you say she is interested? Why do you say PW6 is interested?
My lord, kindly comes to her cross-examination by defense. Page 26 of the paper. My lord, the last paragraph. Shankar is my distant relative. My lord, that Shankar is the father of the deceased.
Distant relative, you are also my distant relative. We are all distant relative of each other. So tracing our.
And my lord, once in their depositions also, they have also earlier said that some of the students of the school where the deceased was studying, they also saw them together. But none of the students were
called for the box. This is good enough. How do you just because he's a distant relative, how can we suspect the entire testimony?
All the Caesar witnesses, there was a Caesar leading to discovery offending weapon, my lord. Caesar witnesses, witnesses number 8, 9, and 10, my lord. They all turned hostile. And that
entirety of the evidence of the hostile witness need not be discarded. Caesar list witnesses only needs to prove their signature, which they have done.
The offending weapon was recovered after more than a month.
On your leading statement.
From an open space.
But on your leading statement, on your identification.
My lord, that leading statement was never examined as well as, my lord.
Not tendered in evidence. Leading statement was not tendered in evidence.
No, my lord. And my lord, one more thing is there. In the 313 of the accused, my lord, specific questions were put before him. And at page number 48, 49, and 55, question numbers are 17, 20, and 59.
So detail 313, good. Kakuli Goswami was examined. Kakuli Goswami was a prosecution witness.
Just let me see. Kakuli Goswami.
None.
No, my.
Kakuli Goswami wasn't examined. This is legal aid. Legal aid or no? Who's the appellant before us? Raisen.
Raisen. He is the sole accused.
your wife was residing in the house of the victim's parents.
No, she is not.
Give me a second.
Well,
You went to the victim's house in order to retrieve your wife. Wife went to the witness box and said that you were the person who tortured her. Therefore, she was left with no other alternative but to take shelter with the victim's family.
no, my lord. She is not the wife, my lord.
PW1?
My lord.
PW1?
My lord, she is not the wife.
Who is she?
She is the Didi, the daughter of the Bhaira Bhai of the Shankar, who is the.
With whom you misbehaved. With whom you misbehaved. At least that comes out.
Kindly, she is the cross-examination of the PW1.
But later on, she came to know that she was already. So that's
PW1.
My lord.
Earlier, you had taken her to make her your wife, and after you came to know that you were already married and that you had a wife. Yes, sir, not that bad.
But even in that case, my lord, the grudge should be upon the PW1, my lord.
No. You had a grudge on PW1, no doubt about it. That PW1 took shelter with the victim's family. You went to retrieve PW1 despite you being married. Victim's family resisted. The boy's father resisted. You couldn't do anything. You had to leave away. The moment after you left, then you came back, took the son and did the needful.
My lord, but in that case, my lord, the Kakoli Goswami should have been examined, my lord. Because unless there is.
There should have been CCTV cameras also, but unfortunately, we'll have to do whatever we have to with whatever materials we have today. That would have been better, no doubt about it, with a 65B certificate of a CCTV camera. But we can't, whatever we have to.
And my lord, the offending weapon also was not sent to.
FSL. Books, study books of the victim, you put it into a water body. Recovered in front of, on your leading statement, recovered by the police in front of the victim's father. Offending weapon, you also stashed away somewhere. Recovered on your leading statement in presence of the victim's father by the police. Now, whosoever else turns hostile is immaterial for us. Yeah, Baba. Maluti, PW1. Maluti is PW1?
My lord.
With whom you wanted to marry?
Yeah.
Her father came to the box and said that you wanted to come to page 21.
31 of the paper book, man.
Page 21, second paragraph.
during the time of occurrence, but the occurrence of kidnapping did not took place at the house of that Shankar Soren. If any.
That very difficult. It's informed me that he also.
Corroborate করে যাচ্ছে
And he again went to PS and lodged the
written complaint.
written complaint. For 3 days, the dead body was
Corroborate করে যাচ্ছে
he is to be pursued.
মানে PW6 is not a witness মানে tutored witness.
No.
Not a tutored witness.
There was some
And more what?
from those people.
You can. Postmortem report says murder by that cutting, chopping.
My lord. And in the depositions, it has been said that the cutlery is available in open market.
Of course.
If that is not sent to the FSL, my lord, the fingerprint might not match.
Need not match. PW6, which is the star witness,
My lord.
he told the de facto complainant on the date of the incident itself. PW2 and PW6 corroborate each other.
My lord,
First day, boy was missing. GD entry made. Then he went about town asking, where is my boy? Father of the victim. PW2. PW2 met PW6 the next day. PW6 told him, told PW2 whatever he narrated in his deposition. Immediately, PW2 went and lodged the police complaint. That is the second day. Yes.
My lord, kindly sees the PW6, my lord, fifth line from the last. Thereafter, Aisan purchased some sweetmeats for the said student and fed him the same. Thereafter, I returned to my house. After 5 to 6 days since that day, I heard that the said boy was missing.
Biren, take it off.
Yeah.
Very good. Come back to tomorrow.
Can it be Monday?
Why? Monday is monthly list day.
Tomorrow I have to take my son to the doctor.
I also had a son, 2 children, and I manage my profession also. You manage yours better. Thank you.
নাম দেওয়া দরকার নেই তো?